After matter, the nature of it, my lord has had his part in many occasions. They have delisted. The matter will be next week, my lord. Any other thing?
May I CORAM to mention, like convicted persons attained the age of 82 years old. LCR already called for my lord.
For what purpose you are mentioning? Bail matter or hearing? For bail or hearing?
For bail.
Give it.
Lordship.
I may pardon to mention, my lord. I may.
Just a minute. Let the judgment be pronounced and we.
Supplement and list for judgment WPC 2171 of 2024.
The writ petition being devoid of merit stands dismissed.
Yes.
I may pardon to mention, my lord, weekly list. I don't know too, because yesterday's my criminal appeal number 265 to 1998. So, when it was in the list, my lord. Yesterday, your lordship was mention was made on my behalf. Yesterday, your lordship was kind enough to provide opportunity to my associate. He placed the judgment, your lordship has seized the judgment. Place the matters, my lord. May I pray, my lord? Matters may be listed to be mentioned for 5 minutes tomorrow.
No, that is a different bench.
Yes, yes. Since your lordship is
we have asked that you may file the written note of submission and citation.
I will file the written note, my lord. There is some
you want to address it. All right, I will talk to Honorable Justice Das and I'll just to remind Mr. Tomorrow it will be that under the heading of to be mentioned, it will be. But get ready with those written note of submission and citation.
Yes.
Apart from that, whatever you want to tell, she didn't say that you are to address. She argued the matter and
he mentioned about my illness, my lord. He mentioned first, since your lordship asked him to mention.
But I think that she was prepared and she was fully prepared, we found. But she did not say that.
He has placed. She has
no, it's all right. It's all right. Yes.
Not in your lordship's board. This is an assignment of my lord the Chief Justice. Mention was made on Monday. I have challenged my lords in this is a writ of 2022 where I have challenged a demand for non-utilization fee and MGQ, my lord. There is an interim order that no coercive measures is to be taken.
Yeah.
Despite that, a notice was issued putting that OS up to auction and the date is fixed to today. May I pray, let it be listed tomorrow, my lords. No, this is in clear violation of the interim orders.
I will talk to Justice Raman because that is the order because I have to take up.
Obviously, Justice Raman has to be a part of this bench because that is an earlier
accept it.
Lord, may I make a similar prayer, my lords? I'm on VC.
Just let me finish here and then
I'm grateful. I'm grateful.
Challenging the rejection of Section 14 application by CJM, my lord. The CJM refused to take police resort to give delivery a person. Now the auction purchaser is facing harm.
Please give it here.
Any day,
Honorable
Chief Justice Court matter, my lord. Regarding tender, my lord, date is fixed to 6/7/25. It may be listed tomorrow, my lord.
Bank matter.
Bank matter.
This is government Chief Justice Court matter, excise matter.
What is the matter? What is the urgency?
Lifting of 118 men. Your lot covered by your lordship
also. Give it to you.
Pardon to mention, your lordship is assigned to the Honorable Chief Justice, your lordship. It's a fresh admission tender matter, your lordship. 120 security guards have lost their jobs, your lordship, by 1 day of notice.
It's all right, but question is that whether
What
it
is the
cannot
pressing
wait till
urgency?
Monday. The question is that.
No, your lordship, because it was yesterday that the notice period ended, your lordship. And I have prayed for a stay of the matter or to allow them to be in service so that later they can claim the wages, your lordship.
No, that's all right. The question is that whether the matter can await till Monday or not. That is
No,
the
Your Lordship, because in the meantime, if it is handed over to the new contractor, Your Lordship, then the matter will become
everything
infructuous.
has been finalized, because once you say that it is to be handed over to the new contractor,
Yes,
then
Your Lordship.
some order must be there that,
No, Your Lordship. Only,
so
only,
how you are
only,
pretending that,
only a 1 day notice was given that within 1 day you have to hand over, Your Lordship. And I filed it within the time period, Your Lordship. The last,
right, but the noting is that exceptionally urgent matter. So obviously, which cannot await till Monday, we have to take up.
Your Lordship, I filed the IA, Your Lordship. If some order is not passed, it will become infructuous.
Press matter of what? This bench or?
My lord, may I mention, my lords?
This
May I mention?
Give it. Yeah.
My lord, there is a batch of writ petitions.
Wait, we are coming there, yes.
I'm sorry.
He wants to make. All right, yes.
Yes.
Lordship, I make pardon to mention it is a
Please
criminal-
wait. Mr. Parija, yes. Please unmute yourself, Mr. Parija. Please unmute yourself.
You have to unmute.
Yes. My lord, am I audible now?
Yes, now you are audible.
My lord, there is a batch of writ petitions which were directed to be listed tomorrow. And the interim order was to continue till tomorrow. So I was only requesting if your lordship could list it tomorrow so that the interim order can be extended.
Is it till next date or it is?
No, it is till the next date. Otherwise, I would not have troubled your lordship.
Okay. Please give the, what
Yes,
is the number?
Mr. Patnaik is there. He will give the whole list. Whole
Okay.
list, my lords.
All right. We are accepting.
I'm grateful to you. Lords.
Yes.
If I may be pardoned to mention, it is a criminal appeal matter, Lordship. The man is in custody since last 5 years.
Where is
And I
your
have-
memo? Land Council, where is your memo?
Lordship, I will hand over the hard copy before the registry of the Honorable Court right now.
Give it. There is no
Lordship.
problem. It will be, yes.
May I make a mention, my lord, of this today's list, your lordship, item 29 of today's list, your lordship. They are appearing for the opposite part number 4. We have obtained consent from the petitioner side. We'll file the.
Just a minute. Please wait. Item number 29.
Yes, your lordship.
In that case, I'm for the petition.
Please.
We have instructions to file the wakalatnama in this matter. The matter may come up
You are supposed to appear for whom?
opposite part number 4, your lordship, on behalf of Mr. L.K. Maran. 40 PCOD, your lordship.
Justice 29th of opposite party number 4K. Okay, opposite party number 4 is Executive Engineer, Bhubaneswar Electrical Division, TPCODL. You will appear for that?
Yes, your lordship.
Okay. You have filed your wakalatnama or you intend to file wakalatnama? You have instruction.
We have instructions to file wakalatnama, your lordship. We'll
What
file.
is your good name, Land Council?
Ruprekha Jana.
Ruprekha Jana, Land Council submits that says instructions to appear for opposite party number 4.
Mr. Maharana is in the panel. Mr. A. L. Maharana is the panel. He is the associate. She is the associate.
Is an associate of L. Maharana.
Mr. A. L. Maharana.
Yes, your lordship.
Associate of L. Maharana submits that they have instructions to appear for opposite party number 4. And the wakalatnama will be filed. By next week, you will file wakalatnama?
Yes, your lordship.
Okay, and you have received the copy of the writ petition?
Yes, your lordship. Yes, your lordship.
And I have also served a copy of the writ petition. And the matter may be taken up a week after. Land Council appearing for the petitioner has no objection for such adjournment.
Any date? Kindly.
We are fixing the date on 11th. Great to place this matter sorry. This is the July calendar. So it will come on 14th. So we commencing.
Can it be 15th, May?
Okay, on 15th of July, 2025. Any interim order has been passed in your favor?
No interim order.
No order.
It's a claim is rejected.
It's all right.
God bless you, lordship.
Your lordship, item 15.
Okay. It will come on 16th because the Tuesday is a separate bench is there. So that is criminal appeal bench. So it will come on 16 July 2025. Okay?
Yeah.
Your lordship, item 15, the matter has actually become, we have already complied with the prayer of the opposite party. So it can be disposed of.
Item number 15, you are for whom?
I am for the petitions, my lord, for the Union of India.
Union of India, yes.
Accountant General Orissa, we have already complied with the prayer what he was asking for regarding the notional increment.
Under Annexure 9, the order has been
Oh, it has become infructuous now.
Yes.
I am opposite party.
Opposite party. Then,
Complied the order of the tribunal.
Tribunal. Shall got the one notional increment.
whatever it may be, the land council, Mr. Acharya Land Senior Advocate appearing
On behalf of the petitioners, my lord.
for the petitioner, Union of India, he submits that the prayer of the opposite party, which was made before the Land and Central Administrative Tribunal, Central Administrative Tribunal, and challenged before this court, has been complied with in the meantime, and therefore at present the opposite party mane kiye thila opposite party number 1
Only one, my lord. Only one.
opposite party is
All opposite party.
writ petition number kena
2614.
writ petition ra ye ta
Corona, sorry.
one opposite party bhul lekha hai na. The land council appearing for the opposite party, he filed the relevant document to that effect. The land council appearing for the opposite party also agrees to the submission made by the land council for the petitioners. The documents
It is also in the record also. That is
that is Annexure 9.
Nine.
Annexure 9 is a part of
No, that is
Additional affidavit. That is additional
Additional
affidavit filed by the petition.
and to that effect, he has submitted that the said document is annexed as Annexure 9 to the additional affidavit filed by the petitioners. Land council for the opposite party also agrees to such submission. In view of such submission, since the matter has become infructuous, it is accordingly disposed of. Yes, sir.
Nine number.
कहाँ कहाँ ना लिखा वो अपन स्लिप में दे दियो तो
Item number 7, my lord. One cap.
just
Opposite party.
One cap.
you are for the
I am for the petition.
I am for the opposite party.
who is seeking for adjournment?
For the petition.
For the petitioner, you are seeking
Yes.
for adjournment. Or any interim order?
No, no.
You have no objection? All right. The land council for the petitioner seeks for an adjournment. Item number 7, land council appearing for the bank has no objection to such adjournment. Put up this matter in the week commencing from 14th of July 2026.
Item number 5, I want to withdraw party.
Mr. Niyamati is there?
Yes, my lord.
No objection.
No.
The land council appearing for the petitioner files a memo to withdraw the writ petition. Mr. K.M.H. Niyamati, land council appearing for the bank is present. The memo is taken on record. The writ petition is disposed of. Yeah.
What tender matter of the Court of the Honorable Chief Justice, my lord? Since he is not there, it probably your lordship has been allotted.
But Mr. which cannot await till Monday.
That's what almost like this. The matter is last date on Monday. The tender filing of last date is Monday. So it can, I filed on the last Friday. And in spite of that, it's not listed. And some other, probably they will give the writ number today. The process that
We give the memo. The writ number has not been assigned.
no,
till
it filed yesterday on Friday, but the office is not yet done in spite of the effort by my clerk.
So,
It is likely to be numbered today, maybe listed tomorrow if with the number.
no, please give that number.
Yes,
It
I'll
can
give
be
you the number.
accepted by, if you file even by lunch also, there will be no problem. So by lunch, just collect the number, mention, so and give it, you will accept. And the matter will be taken up tomorrow, all these matters which are.
Should I mention the number and give the memo only, or I will come and again mention?
No
Not
question of
necessary.
mentioning, just give the number of the writ petition, that's all.
I'm
And-
collecting it and giving
Just
to your
give,
lordship.
no further mention. Yes. Photo जैसे matter mention हुआ.
Supplemental list, item number 1, item 2,
The petition is filed for a direction to the learned district magistrate to dispose of the application filed under section 14 of the surfacing on it. On the last appeal, it is directed me to submit the entire order sheet and the essay pending before the BR. Wherein, my lords, our case was that no stay, no interim order is.
That is the exact.
So I have collected the entire order sheet and nowhere the stay is there. Only any type of interim order.
It was not disposed of because another matter is pending. That's what the.
But in that matter, there is no stay order.
No.
So what is the problem? You see, the prayer is just to dispose of that this case number 14 of 2024 under section 14 of the Surface Act, right? So somebody made a mention before, perhaps the opposite party number 1, that another case is pending. He said that the case is pending, no doubt it is correct, but there is no stay order. So if there is no stay order, there is no obstacle in proceeding further in that section 14 application. So
Please 7 except I except credit like a copy I except I and except 3. Wait about the guys. Pending debt report. সেইগুলি was person.
See that particular order has been annexed as annexure 3 to the interim application.
To the IA.
IA number 21557 of 2025. Have you got a copy of that interim application?
Case record is put up today.
Yeah, please read it out.
Case record is put up today. Additional comment period Hon'Ble is present. There is the case record. Representative of the authorized officer Bank of Baroda. ROCRP Sambalpur is present. One is the advocate on behalf of the borrower is also present. And an advocate for borrower stated that another case is pending in the court of the debt recovery tribunal courthouse relating to this matter. This fact also concerned by the authorized officer. Let's case after
So why it will await if there is no stay order? So if there is no legal impediment in disposing of that matter, if that man is aggrieved, should press before the DRT to pass an order of stay. He has not moved. This is the order dated 18/12/2024. Why it has been passed like that after disposal of the proceeding before the DRT?
Is there any bearing in with this matter? So if there is no legal impediment, let it be done. We can see that.
Look on the Land Council for the petitioner, Mr. Niyamati, has produced the order sheet of the Land and Debt Recovery Tribunal Qatar in essay number 8 of 2024 and submits that no stay order has been passed in favor of the opposite party number 2, Vibhuti Ranjan Mahanti, who is the applicant in the aforesaid essay. And what was challenged in the essay?
Surface proceeding. Surface proceeding.
Challenging the surface area. Since there is no legal impediment in the in disposal of the miscase number 14 of 2024 by the opposite party number 1, that is district magistrate cum collector on board, we are of the view that the collector should not have passed an order on 19/12 or it is 18/12/2024 in putting up on the aforesaid miscase for disposal, for consideration after the disposal by the Debt Recovery Tribunal Qatar.
Deferring the hearing.
They're deferring the hearing and awaiting the disposal of the essay in before the Land and DRT Qatar. In view of the limited nature of prayer made in this writ petition, we direct the opposite party number 1 to expedite the hearing of miscase number 14 of 2024 and dispose of the same within a period of 3 months from the production of the certified copy of this order by the Land Council by the petitioner. It is made clear that this court has not expressed any opinion on the merits of the aforesaid miscase. Writ petition is disposed of.
The act says within 30 days or not beyond 60 days.
Is expediently possible.
There is a time limit this time. We have to.
Section 14.
Already time is expired.
That time. Which is that provision?
Section 14. Section 14 provision orders. Provided further.
Which one?
Section
14.
14.
14 no co-provision.
Provision.
Second provision. The Land and Council for the petitioner also brought to the notice of this court the second proviso to section 14 1 bracket ray IX of the Surface I Act, which states that if no order is passed by the Chief Metropolitan Magistrate or District Magistrate within a period of 30 days for the reasons beyond his control, he may, after recording the reasons in writing the same, pass the order within such also period, but not exceeding in aggregate 60 days. In view of expeditiously for them, you 3 months enough. Yes. Keeping in view the provider, yes. Language to fix it. Yes, next.
Item 3.
Yeah.
Your Lordship, I'm appearing on behalf of Rupesh Kumar Kanungo for Union of India. I need any adjournment. He's suffering from fever. He informed me today morning.
Mr. Kanungo is.
Yes.
So,
Any.
you have received the copy of the writ petition?
Yes.
If your Lordship, if he wants that it should be decided on merit, then I'll give a copy of the writ petition. I think
He has received the copy. He has received the copy of the writ petition. Yes. So let
Maybe
it
adjourn
be
to any date.
next week.
Any date is fine.
On any date, you must
next
be
week.
knowing about this. So we can keep it next week. But if you want further adjournment, tell us. We can take up also on 14th July
this is
2020.
arising out of
No,
the order
next-
passed by
next
the Land Central Administrative Tribunal, rejecting my application for condonation or delay in filing the review petition and consequently dismissing the review petition.
No, it's all right. If
On
the
the last
application,
occasion, when your Lordship heard the matter, your Lordship was pleased to pose me a question whether the decision that has been referred to by the Land Tribunal to hold that this second review petition is barred is applicable or not. When my assumption was it is not applicable. Since my friend
we
Mr.
have
Rupesh
we have
is not
mentioned that decision also.
Yes.
That S. Madhusudan Reddy versus.
Absolutely, madam. So if my friend is not there, your Lordship may fix a short date because
All
he is out of
right.
employment.
What is your
Since long.
name, madam? Just write it down. So and so appearing for Mr. Rupesh Kumar Kanungo. What is the designation of Mr. Kanungo? Is the
Senior counsel for Union.
senior panel counsel.
Yes.
Senior panel counsel for the Union of India. That the Mr. Kanungo is not well, and the matter may be adjourned to some other date. We further submit that he has received a copy of the writ petition. Mr. Mishra and senior advocate appearing for the petitioner submit that a short date may be fixed. Place this matter in the week commencing from 14th of July 2025. Yes.
Obliged, Your Lordship. Okay.
Item 4.
For Mr. Sahoo,
My lord.
you are Mr. Paniga, you are appearing for the bank. I think this matter.
This matter, last occasion, my honored friend has submitted an affidavit stating there is.
The instruction is that if you are ready to pay 85 lakhs on or before 10th
July 20.
So what is your instruction?
My respectable submission in this regard, because the 75 lakhs ought to have been paid on 31st March 2025.
We don't want to.
On the 3 months to 3 months, only 10 days.
We will not.
10 lakhs is not coming.
It's a question. It's a question of. If we said we would not have entered into it all the thing, but you said that I'm ready and willing to clear all the outstanding dues. That is how we asked Mr. Panigai to obtain instruction. He said that it is not.
See, in the writ jurisdiction, why we will adjudicate all these things?
If this being the question, I respectfully submit.
You may have a difficulty, but you have to persuade them, not us.
So for this settlement, my proposal under
Mr. Sahoo, even if you persuade us, we can't help you. You have to persuade them.
But the agent today, they have not taken not decision in Annex 1 below. What is it regarding that? Because they have accepted the money and
You
are
will
not.
simply write that you are not agreeable to the proposal submitted by the bank. Writ petition is disposed of. That's all. Because
Page 61 of the writ petition may be seen, my lord, for a moment.
no, that's
Same issues pending before QIT.
You made a categorical submission that I will pay back the money. Is it not your submission on that day? And let him obtain. And he has, the bank has reduced it. It was 1 crore some odd. And they have said that they are
17
agreeable, they are agreeable for 85 lakhs.
Yes, my lord, Lordship will dispose of it. 75 lakhs it would have been paid on 31st March 2025. Only 3 months, 10 days. 10 lakhs will not come out.
କେମିତି ହିସାବ ହେଲା କଣ ହେଲା ସେମାନେ ଆପଣ ଯିବେ ବୁଝେଇବେ ସେ ତ
To do those.
This is the-
And you know,
And my law says, my lord, that the Kutte judgment, my lord, Kutte Energy Private Limited versus authorized as a PNB, if the settlement proposal, if the offer amount is paid, if they are not agreeable, that amount to be returned. That is paragraph 9, my lord. That is Supreme Court judgment, my lord. On that basis, your lordship kindly dispose of, because if they are not agreeing, they may proceed in accordance with the law.
Seek your appropriate remedy here, not here. We just passed the order on your submission, Mr. Sahoo. The 3 orders have already been passed.
Milord, 85 lakhs is there now. If they are intending to recover the entire money, Milord, lordship kindly.
If they have already reduced from 1 crore some odd to 85
Who will
lakhs.
pay the interest part? Milord, my respectful submission is on November 2022, their dues is 1 crore 9 lakhs. After 1 crore 9 lakhs, it is 60,000 will pay. Then maximum is 50 lakhs. Then 50 lakhs are now they are paying the 85 lakhs, Milord.
Do you expect us to do this calculation here?
Milord, that is the only no, Milord, because the reason means DRT regarding the settlement, DRT has no power.
Mr. Sahoo, you yourself said on the very first day that I am supposed to pay an additional amount of rupees 75 lakhs by 31/3/2025. Now to say that it is to be paid
it's 10 lakhs.
by just a minute, 85 lakhs by 10th July. So now it's a question of calculation. So we are not supposed to calculate it. How it became 75 lakhs through 10 lakh टंका केमती 4 मास रे हला
as against 1 crore 17 lakhs. They are demanding 85 lakhs.
85 lakhs.
And you say 75 lakhs. And that can be sorted out in the bank only, not here.
My respective submission, only 2 years, 8 months, that such an amount will not come up after depositing of 60 lakhs.
You have to pay, they have to receive. Who are we to tell?
My respective submission, when I just submitted the OTS proposal along with the amount, with the bona fide intention, with the bona fide of the party, because that is not a debt due. Debt due, they will recover in accordance with the law below. That doesn't.
We are disposing it of, Mr. Sahoo. Sorry, the Mr. Tuna Sahoo and counsel appearing.
That at best delayed payment, 10 lakhs is not coming.
Bujan to upon right one.
Annexer 1 may
we'll observe that.
We will observe that.
Annexer 1 may kindly.
1 minute we will observe that. That may help.
Annexer 1 may kindly.
Please listen to the order, Mr. Sahoo.
Annexer
1. An order was passed on 25/6/2025 when Mr. Paniglahi Land Council appearing for the opposite party number 1 and 2 bank submitted that the total outstanding dues against the petitioner Ranjan Kumar Singh as 1 crore 17 lakh 5,443 after adjusting the amount paid by the petitioner, and the bank is ready and willing to settle the loan account as an exception basis and a goodwill gesture if the petitioner pays a sum of rupees 85 lakh on or before 10th July 2025. We asked Mr. Sahoo, the Land and Counsel for the petitioner, to take instruction from the petitioner regarding payment of such amount. Today, the Land Counsel for the petitioner submitted that the calculation as being of 85 lakhs was on a higher side. Stop. In view of such submission, since the petitioner is not ready and willing to pay the sum of rupees 85 lakh as proposed by the bank to settle the loan account, we are unable to grant any relief to the petitioner in this petition. It is open to the petitioner, however, it is open to the petitioners to approach the bank for settlement of the loan account. Accordingly, the writ petition.
Lord, Annexer 1 has not been disposed of.
Same thing we have observed.
Yes, next.
Item 6.
Of the petitioners in this case,
6.
to challenge the order
Item
passed
6
by the
was what?
Central Administrative Tribunal dated 27/6/2024.
Just a minute. So, which order you are challenging?
You also the order dated 27/6/2024. By that order, 2 original applications been disposed of. In one original application has been filed challenging the initiation of disciplinary proceeding and the imposition of the penalty. And the other disciplinary proceeding has been initiated. That, let's say for a moment, if I read the order of the disciplinary proceeding, then I can submit on the.
No, just a minute. Here, Manoj Kumar Thakur, who is the applicant before the London Central Administrative Tribunal, it is your submission that he filed 2 original applications.
2 original applications.
So far as this original application is concerned, what he has challenged?
Here it has been challenged that the order of punishment was communicated to him in 2018, imposing a penalty of reduction to the scale of 3 stages down, and
so that he challenged.
So
what?
There the Honorable Tribunal upheld the same.
No, that is under challenge.
No, that is not under challenge.
Writ petition re Union of India jehetu asichi, the order must have been passed in favor of the opposite party.
Yes.
You are challenging that.
Yes.
So that is why we are asking you that what relief was sought for by the opposite party before the London Central Administrative Tribunal in the original application, which was allowed, and you are challenging this.
The punishment was imposed of reduction to the grade of sorting assistant in the year 2018. And the condition of the punishment order is, it is for the period of 3 years, and he will be, within that period of 3 years of punishment, he will be allowed to draw pay and allowances that he would have drawn if he had not been promoted to the post of Inspector of Grade.
You come to the operative part of the order.
Yes, Lordship. That is page 60 of the order that has been challenged in the OA. There are 2 parts of the order, Your Lordship. That's why I'm page 60, Your Lordship. That is the order of the.
You are challenging the order dated 27/6/2024, passed by so OA number 260.
260.
Right?
Yes, Lordship.
So
that is 160, Your Lordship. 160 of 2022. 2 OAs are there.
2 OAs.
814 of 2019.
You are challenging 166 you are challenging.
Yes,
okay. In 166, so where is that operative part?
Lordship. The operative part is at page 35, Lordship.
35. So far as 163.
166 is correct.
Okay.
Para 15.
Para 15.
Para 15 it starts, and the conclusion part is in paragraph number 18.
Yes, page 38, paragraph number 18.
It is not 38, it is page number 37. Internal page is 22. It starts from paragraph 18, starts from page number 22.
22, yes.
Please read it out.
Lordship. Admittedly, in consequence of the order of punishment, the applicant relinquished relieved from the post of inspector on 24/9/2018 and posted to Sambalpur RMS as a sorting assistant, but he did not report to duty and remained absent by submitting medical unfitness. Since the applicant has already been relieved from the post of inspector as the effect to the order of punishment, and he ought to have been reported as duty to this sorting assistant, but he did not report, he is deemed to have been continuing in the post of sorting assistant. In view of the above, is well supported by the decision of the Honorable High Court of Punjab and Haryana in the case of the High Court of Punjab and Haryana Chandigarh versus Jaswant Singh in LPA number 1852 of 2016, decided on 3/9/2019, wherein the Honorable Court has held that the punishment imposed in disciplinary proceeding is to take effect from the date the order is passed. Therefore, on his report to duty, obviously and axiomatically,
applicant's pay ought to have been fixed in the grade of sorting assistant from the date he was reverted to the cadre of sorting assistant till his restoration to the cadre of inspector in compliance with the order of the DA and A, and after completion of the period of punishment, he will be restored to the cadre of inspector. As per Government of India OM number 7 to 1964, such an order can be passed on joining in the post of sorting assistant. Insofar as regularization of his leave is concerned, it's up to the respondents to consider the same after joining and submission of the leave along with the medical certificate, etc., as per rules, ordered accordingly.
Which part you are agreeing?
We are agreed on the part, Your Lordship. 18, the order of punishment was passed. It was communicated to him. He never joined in the post of reduction.
Yeah.
And in 2028, because 2021, when 3 years period of punishment was there, after 3 years, though he didn't join, honestly stayed on leave, in 2021, on the date of completion of the period of the punishment that was ordered in the, that is assailed before by the petitioner opposite party before the tribunal, he filed a representation before the authorities that because the 3-year period is over, I may be permitted to join in the original post, that is inspector posts. Now the contention of the petitioner as of before this honorable court is, once a punishment is imposed and it is not undergone by the delinquent employee, he cannot take a recourse that I remained on his leave and the 3 years period is over, and so I am entitled to join in the post, original post, for which this reduction order has
He
been
has to
passed.
undergo the rigors of that punishment
Yes,
even after.
Yes, ma'am.
That's what you are saying.
The honorable tribunal has ruled that once it is communicated, the punishment runs from the date of communication, not for the date he has joined in the post of sorting assistant. Now, in that case, the honorable tribunal has relied upon this judgment of Honorable High Court of Punjab and Haryana, of Chandigarh and Basant Jaswant Singh. I have also annexed that judgment before this honorable court. That is annexed 4 years. I say that this judgment is not applicable to the present case because the contentions before that case was completely different from this case. Because if you also may kindly see page 89.
The issue is now whether on the date when the order was passed, it will be effective, or the date when he joined it is effective.
Lordship.
You
Okay.
said the date he joins, that is the effective date, not the date when the order is passed. That's what the whole case.
Lordship. And one more thing, Lordship.
What about the other case? You said that two
The other case was challenging the disciplinary proceeding, this order, impugned order passed in the disciplinary proceeding.
So what happened?
That was upheld. Upheld by the tribunal.
Has he challenged in that?
No.
That you are not agreeing.
He has not challenged and we have not challenged because it is in our favor. So do not challenge. Because in that case.
I mean to say he should have challenged when the order was upheld by in the original application.
Yes.
So you have not received any notice in that matter?
No.
He is not challenged.
And one more thing, Your Lordship, because that was not brought to the notice of the Honorable Tribunal, that's why I could not make a averment with respect to that. The opposite parties has already joined in the post of the reduction. But that was never brought to the notice of the Honorable Tribunal by either party. Since 2023, he has joined. Sees. It is not that he has not accepted. In 23, he has accepted. In 24, this has been passed.
And he has not challenged that part.
No, Your Lordship.
Then he accepted it.
He accepted and he has joined.
Then he has to undergo the rigors for that 3 years.
Yes. But this fact could not be brought before the Honorable Tribunal by either of the parties. It should have been, but during the pendency...
Then go on bring it to the notice of the court.
Your Lordship.
If we should file a review. If this fact was not brought to the notice of the tribunal...
It was not discussed by the... How can a new thing will be considered by us which was not brought?
That's why I just brought to the notice of the Honorable Tribunal. You also kindly see that he has already joined.
Notice is required to be issued to the opposite party.
Or he can withdraw it and with the liberty to file review.
That you can do it.
You can withdraw with the liberty to file review in view of this.
Yes, Your Lordship.
Otherwise, what will happen is we have to issue notice, he'll come and all this thing.
The same thing will happen because it came to my knowledge when filing of the petition because it was not a averment before the Honorable Tribunal.
Documents.
So I could not make a
not
averment.
brought to the notice.
All right. This petition has been filed by the Union of India and others challenging the order dated 27/6/2024 passed by the London Central Administrative Tribunal Cuttack Bench matter in OA number 260/166 of 2022. In observing that in relying upon the decision of the Honorable High Court of Punjab and Haryana in the case of so and so LPA number so and so paragraph number 8 and holding as follows তারিখ স্তরে লেখা হয়েছে যেতিক সেটা টিপি দেবে তাই up to so far as regularization আছে সেটাও টিপিবেনি বাট বাকিটাও টিপি দেবে তাই না in so far as regularization সেটাও omit করে দেবে that is in page number internal page is 23 and running page is 38 তাই না the Land Council for the Union of India submits files a memo with the joining letter of the opposite party dated 8/2/2023 in the post of sorting assistant. Sorting assistant in which place?
Sambalpur, Jharsuguda.
In Jharsuguda. And submits that this fact of joining by the opposite party was neither brought to the notice of the London Central Administrative Tribunal by the opposite party nor by the petitioner. And it's a very material document which ought to be considered by the London Central Administrative Tribunal for in the interest of justice and to arrive at a just conclusion. And therefore, the petitioners intend to withdraw this petition to approach the Land Central Administrative Tribunal by filing a review petition bringing the notice of the Land Tribunal the joining letter of the opposite party dated 8/2/2023 and to argue the effect of such joining letter. The joining letter file, the memo is taken on record. The writ petition is disposed of, giving liberty to the petitioner to approach the London Central Administrative Tribunal in accordance with law. Yes.
Your Lordship, one more prayer, Your Lordship. I filed a miscase. In fact, they said they filed a contempt application and that is posted to 3rd of July. And
Which
in
where?
that Your Lordship, the 10510/2025.
Obviously, once you file there, you can
10 days,
make a
Your
prayer.
Lordship, within 10 days, I'll file it.
The submit that you will file the application within the 10 days.
No persuasion till that.
No, we cannot pass that order. Yes,
And my lord, 30 days, the period of limitation may be considered by
the period of limitation in filing the review petition shall be taken into account in view of section 14 of the Limitation Act. Yes.
Obliged.
So please give your designation, Mr. Kasio.
My lord, I'll give it in that.
You are the Central Government Council or
Senior Penal Council.
Senior Penal. Yes.
Obliged.
Item 8.
8, Mr. Fali.
Plan 3 is the amendment. I've prayed for amendment of the formal amendment that Annexure 17 and Annexure washing and stay of Annexure 17. That is at flag B and flag C. Both the amendments made, my lords, allowed.
Where is that IN number?
IA number 10633 of 25. That is amendment of the main prayer. And
Yes, Mr. Das, any objection to the?
I have received one amendment, 10333. 10637.
That is the only petition.
No.
All right. IN number, all right. IN number 103-637 of 2025. There is an application filed by the petitioner. Taking for an amendment as per this schedule, which is for the amendment of the prayer portion of the interim application number 10270 of 2025. It is not for the main writ petition.
main flag B is for the main 10633, washing of 17.
But please see in the schedule you have mentioned that you require the amendment of the prayer portion of the interim application only, not the.
There are two interim applications.
Oh, I see. One is this 10637.
That is what your lordship is probably looking at.
Yes.
That's the IE.
The other is?
Other is 10633.
Okay. All right. So the Mr. Das and senior advocate appearing for the opposite party has no objection to the prayer for amendments. Accordingly, you are appearing, Mr. Das, for which opposition?
For corporation.
For the corporation, has no objection. Accordingly, the prayer is allowed. Are you filing that consolidated writ petition?
No, it's ready. It's ready. We'll file it now.
We are just mentioning by tomorrow you will file.
If you may permit me, I can file it in court if you
The land, the amendment, the consolidated writ petition. So also the consolidated interim application, both will be filed during course of the day, giving copy to the land council for the opposite parties. But we are not mentioning because you are not filing, you can file during course of the day. If you want the matter to be listed.
They have also filed a counter. In the meantime, my learned friend.
Please tell us a date so that we can, if you file it, the consolidated today in court. So when you take, as per your convenience, we can take up the matter. Tomorrow it's a different bench is there. So you can take off next week if you say.
The auction is on 5th, that's the difficulties.
No, but tomorrow this is separate bench is there altogether.
Now, in the meantime, there has been one development, your lordship's appreciation, my lord.
We can bring it day after tomorrow.
Yes.
But not tomorrow.
Yes.
All right.
Yeah.
Is this matter on 4th of July 2025? Yes.
I've already filed counter maybe.
Counter affidavit is not on record.
Not on record.
It hasn't come.
We filed it yesterday.
Mr. Das submits he has filed the counter affidavit. The counter affidavit be placed on record. Yes. Scanning fanning kari logay dawa to. Any scanning any kali question. Fourth it will come.
No, great.
Item 9.
So this has to come with the Arata Soitashi. Outer petition Soitashi, WPC number. Yes.
I have already appeared there for rested upon the Stone of Court. My name has not been reflected in the court this time.
So, no, notice has been issued to respondent number 4 to 6.
Yes.
You are appearing only for 4.
I'm appearing for the 5.
Just let us see who are these 4, 5, and 6.
My lord, who is the managing committee?
Just a minute. 4 is the managing committee. So give the names so that Wakalatnama is not on record.
Yes.
So,
My lord, I am appearing on behalf of OP number 6.
Just one by one. 4 fine council. Actually, Wakalatnama copy is ଆପଣ ଦେଇଦିଅନ୍ତୁ ଆମେ ନାଇଁ କିଛି ଇଏ ମାରନ୍ତୁନି ଖାଲି ଦିଅନ୍ତୁ ମୁଁ ଡାକି ଦଉଛି ଅର୍ଡର ଆଉ 6 ର ଆପଣଙ୍କର ଫାଇଲ କରିଛନ୍ତି वकालत ଅଛି କପି ଅଛି वकालत ଆଚ୍ଛା ଲେଖନ୍ତୁ the Mr. Sangram Jena, Land Council submits that he has already entered appearance for opposite party number 4.
Respondent number 4.
Sorry, respondent number 4 and filed wakalatnama on
Day before yesterday, Monday, 30th.
on 30th of June 2025. দেখুন তারপর সেটা দেখুন আমি ফেরিয়ে দিন Mr. Prakash Kumar Raut, Land Council submits that he has filed wakalatnama for respondent number 5. Respondent number 5 on Kebe
30th.
On 30th of June 2025. Stop. ଆପଣଙ୍କର ନାଁଟା କୁହନ୍ତୁ
Priyaranjan Mishra.
Priyaranjan
Mishra.
Mishra.
Aye.
It is the wakalatnama is in your name.
My lord.
Priyaranjan Mishra, Land Council submits that he has filed wakalatnama for respondent number 6
On 30th June.
on 30th of June 2025. Let all the wakalatnama be placed on record. The name of the Land Council for the respondent number 4, 5 and 6 be mentioned in the cause list. Stop. So what is the delay for which notice has been issued? 399 days. Any of you intend to file any objection to the condemnation? So file the Land Council for the respondents number 4, 5 and 6 submit that they intend to file objection to the delay condonation application. How much time you require? 7 days. 1 week time required. So list this matter in the week commencing from 14th of July 2025. Objection, if any, to the delay condonation application be filed in the meantime, serving copy on the Land Council for the petition. Take.
Merits there is nothing. Merit to each night.
Item 10.
Mr. Mishra?
Yes. The petition challenging the
Who is for the opposite party?
No, I is pending.
Which one? Which one?
One IA is 14,168, another 11,931.
Just a minute.
With my certificate, my lord, the award was stayed. This court.
Just state the number of the IE on.
14,668 ওটে
Yeah.
আর 11,941 ওকে স্যার পাই
So you are for the
workmen. This court directed, stay was vacated, directed to pay 40,000 to all 45 workmen. That was vacated by this court.
When?
Now I'm giving the date. My lord, 9/1/2023. My lord, they have paid 45 workmen.
Just 9/1/23.
Man. Yes.
Have you got a copy of that order with you? No, you please read it out.
Man. Mr. Mishra Leonard, Senior Counsel appearing for the petitioner seeks some time to prepare the data note of submission. The court note that in order our directed the petitioner management to pay 20,000 to each 45 waiver apart from 1,000 rupees per month till their re-engagement. Mr. Mishra Leonard, Senior Counsel for the petitioner said that some of the opposite parties have already been re-engaged by the petitioner, but because of a blanket stay order passed by this court way back
on 25 August 2014, no amount whatsoever has been paid to any of the above for over 8 years now. That in that view of the matter, while adjourning the matter at the request of the Mr. Mishra and senior counsel for the petitioner, 10th May 2023, this court modified the interim order dated 25 August 2014, directs that petitioner will pay to each of the 45 hours a sum of rupees 20,000 per hour as directed by labor code. They, as far as the remaining part of the import order is concerned, is continued. The payment be made within 1 month from today. It will be open to each 45 hours to approach the petitioner for payment of the strength of this order. Petitioner will place before this court the proof of compliance of the order on the next date of hearing. But they have paid 25 workmen. 10 workmen already died. 10 are living, 20 workmen, and they have not paid with that 20,000. So this court directed, they made some regarding discrepancy of name. So this court again directed you deposit the entire amount before this court. That order, my lord, will actually find on 25/9/2004, my lord. Entire amount of for 20 workmen has been deposited.
Just a minute.
20.
May
kindly see the order dated 13/8/2024, order number 8.
25/9/24. Read it out.
No, before that, your lordship, may kindly see that the previous order, 13/8/24.
25/9/2024 कौन वाला?
They have, this court directed
that amount was given, draft was given before this honorable court, for which has been kept in deposit.
And also
for that, your lordship sees the 13/8/2024 order, just the previous order, order number 18.
13/8/2020.
Yes, yes.
Please read it out.
Yes. Mr. Mishra and senior advocate appears on behalf of the petitioner management and submits interim direction could not be carried out in respect of all 45 weavers because 10 have died, and in respect of another 10, there are discrepancies regarding the claimants. His client is to pay rupees 20,000 to each of the about 20 waivers. Remaining 25 of the 45 waivers have been paid. Mr. Rathal and advocate appears on behalf of the opposite parties and submits his clients will render every assistance to remove allegation of discrepancy regarding those who have died. Their legal representatives are entitled to the payments. We noticed from the order dated 9th January 2023 of coordinate bench, there was a further direction in impugned award dated 31st March 2014 to pay rupees 1,000 to each weaver till their engagement. That direction remains stayed pending adjudication of challenge to the award. Petitioner will deposit rupees 4 lakhs with registered judicial on or before the adjourned date. On the deposit made, the registrar will invest the same in short-term interest-bearing deposit account with any nationalized bank to be kept renewed to the credit of the petition. We expect assistance from Mr. Rathor regarding removal of discrepancies, if any, in respect of 10 surviving weavers. Further assistance is required in respect of the deceased weavers. The legal representatives must produce legal aid certificates enclosed to their respective affidavits affirmed before the executive magistrate. List on 4th September. Thereafter, you will also have seen that 4th September order, which has been deposited. Mr. Mishra, and senior advocate, appears on behalf of the petitioner and causes handing up of the memo of date. With it is attached demand draft number so-and-so dated 2nd September 2024, issued by the State Bank of India in favor of registered judicial for rupees 4 lakh. He submits, thereby there has been compliance with direction in order dated 13/8/2024. Ms. Behera, advocate, appears on behalf of opposite party. Paragraph 4 from our order dated 13th August 2024 is reproduced below. Then your quotation is there. Then registered judicial will act in making investment. List on 25th September. And on 25th September, your lordship, Mr. Lamkar and advocate appears on behalf of the opposite party and submits there is no discrepancy regarding the identities and claims for receiving aggregate sum of rupees 4 lakh deposited by petitioner. Mr. Mishra and senior advocate appears on behalf of the petitioner and submits there is another aspect of challenge to the impugned award dated 31st March 2014. It is regarding direction for engagement The money deposited needs to be disbursed. That will take care of the first part of the petitioner's challenge to impugned award. For the purpose, we require Mr. Author to obtain authorization by way of affidavit sworn jointly and for severally before the executive magistrate or any other way authorizing him to receive the deposit for purpose of disbursal to the workmen and or their legal representatives whom he represents. List on 25th of
No, then the discrepancy part is taken care of.
I think so. You must have filed the affidavit.
Okay.
There isn't, I have known.
Filed in that IA number 14,158.
There have been certain mismatch of the names of the particular persons who are claimants. That is why the discrepancy was there.
What happened? Why you have filed this interim application?
Well,
To release
For release of the amount.
Release of the amount.
that is to be released in your favor.
In my favor, as per the order,
Right.
I will distribute among the workers.
And produce the document necessary.
I will give the receipt. Before the court.
Any objection to that? That is the order passed.
Your lordship's order, so I can.
Oh, that is court's order.
It's all right. Lekondo, IA number 1.
What about the second limb? Re-engagement.
What
about the second limb of the order, re-engagement?
It has to be adjudicated, your lordship.
Made it clear. Lekondo, IA number 14168 of 2024. This application has been filed by the management of Sambalpuri Vastralaya.
Workman matter. Where workman?
Sambalpuri Vastralaya Handloom Cooperative Society Limited.
No, who has filed this?
I have filed. Workman have.
As a workman filed by the workman. For release of an amount of rupees 4 lakhs,
4 lakhs,
which was deposited with the registered judicial of this court. So, the London Council for the appellant placed the order dated 9/1/2023 of this court. Which the operative portion of which reads as follows. Quote paragraph number 4 and 5 of the order dated 9/1/2023. The Land Council then placed the order dated 13/8/2024 and the operative portion reads as follows. Quote paragraph number 4. Mr. Mishra and Senior Advocate placed then the order dated 4/9/2024, which indicates that the demand draft dated 2nd September 2024 issued by the State Bank of India in favor of registered judicial for an amount of rupees 4 lakh has already been deposited with the registered judicial in compliance with the direction of order dated 13/8/2024. Mr. then placed the order dated 25/9/2024, operative portion of which reads as follows. Quote paragraph number 3.
There you also finds a particular direction was there that the affidavit has to authorization has to by way of affidavit sworn jointly and for severally before the executive magistrate or any other way. Here the affidavit which has been filed is before the notary.
No,
That is for your lordships.
not necessary, that's the matter. In the IA is there.
IA?
In that IA, all are the affidavit before the executive magistrate master.
Notary public, Burger. Page 8.
On notary public.
Yes.
On notary public.
All notary public.
All notary public.
What they have stated in the affidavit?
They have authorized me to withdraw the amount.
What is that paragraph? Just let us know. Come to that
Paragraph 4, your lordship.
Please swear this affidavit in authorizing our counsel's seeker so-and-so,
Yes.
advocate so-and-so, 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 to receive the amount on their behalf, to pay them as per
in the interim application at IA number 14168 or
1416.
An affidavit executed by the workman has been annexed as annexure A.
unpaid workmen. Unpaid
workman.
Workman and nominee of the workman.
Workman and nominee of the workman. Two separate affidavits.
Two
separate affidavits have been filed in which authorization has been given to Mr. Sikar Kumar Rathore, advocate, to receive the amount on their behalf and to pay the same as per the order of this court. Mr. Rathore, land counsel for the respondent, submits that if the amount is paid to him by the Land and Register Judicial as per the order of this court, we will pay the same to the unpaid workman as well as the representative of the workman who are already dead.
Nominee.
Nominee of the workmen who are already dead, and produce the documentary proof.
Submit the original.
Submit the receipt in token of such amount by the workmen and their nominee. By the next.
May your lordship write instead of nominee the legal heirs, your lordship?
Legal heir nominee.
Nominee bracket.
Legal heir nominee korchundi.
Legal.
Morigala par ko.
All right. Legal heir.
Legal heir nominee korchundi.
Legal heir will again create complication.
Yes.
For 20,000 rupees, if 5 legal heirs are there.
No. Legal heir have represented one person. That legal heir representative will be there.
Nominee and or legal heir.
Legal heirs nominee is there.
Yes.
They have nominated.
And obligor.
And obligor legal heir. So put up this matter on kepe rakhiba kon. ଆପଣଙ୍କୁ ତ ଟଙ୍କା ହ୍ୟାଣ୍ଡ ଓଭର କରିଦିଆଯିବ by end of this week. Question is that ଆପଣ କେବେ ସେଗୁଡା produce
ମୁଁ ତାଙ୍କୁ ସବୁ ଡାକିବି ରିସିପ୍ଟ ମଗେଇବି
ଓ ଆମ ଆପଣ କେବେ
ସମୟ କରି ଲୋକ ଆସିବେ
You have taken the responsibility.
I will receive the money. ପୁଣି ତାଙ୍କୁ ପୁଣି withdraw କରି ଦେବି ନା
ଆପଣ କଣ ଟଙ୍କା ଦବାକୁ କି ମନା କରୁଛି ନା କଣ? You will receive the money by this week. Question is that when we will prove the documentary proof that they have received the amount, those workmen and this. So that you have to say, you said 20 days. All right. So let us fix it on 28. All right. The Land Register Judicial shall disburse sum of rupees 4 lakh in favor of Mr. Sikar Kumar Roth, advocate, on or before 4th of July 2025. The matter will be stayed in the week commencing from 28th of July 2025 to enable Mr. Roth to produce the original receipt showing the receipt of the amount by the workers obliquely nominee bracket legal heir of the deceased worker.
Was it invested in the interest bearing account? Then the interest accrued by now is also to be dispersed equally among themselves. Because interest must be there something. 4 lakhs.
The 4 lakhs with the interest accrued.
Accrued interest.
And sir, that shall also be equally
Which is to be equally disbursed to in favor of all the workmen and their manual.
That would have strengthened.
That interim order has modified.
That is a
Yes, next.
Interim order to be continued. Your Honor.
There is an interim order dated.
That is 9/1/2023. Has to continue.
Order.
Modified interim order.
Yes,
If it is not there till the next, then no further to write.
Yes, next. और 3C 7 है 2025 right? Next.
Item 11.
Last week, as per your, the order of your lordship, I shoved a copy, additional copy of writ appeal into annexes to the Union of India.
How will the matter? What you are challenging, Mr. Samant?
I'm challenging the order of this honorable court, honorable single bench. The writ petition 23250.
That is annexure 38. Order dated 17/2/2017, passed in WPC number so and so, right?
Yes. Okay. And that is disposing February 2017, 17 February. And that order has been challenged.
In the KIT University, which post you are holding?
I was holding a post of assistant professor.
Assistant professor.
Although it's that is argument.
What you are challenging over before the learned single judge, which has been negatived, for which you filed this writ appeal?
May I get a permission or seek that make a
You
summary?
have got that date chart. Have you prepared a date chart?
Yes.
Where is that?
Already.
You have already filed.
Already submitted.
All right, just we are verifying it.
If your lordship wants it hard copy, I.
No, it's already with us. That starts with the order date is 12/5/2010.
May I submit the?
Have you got an extra copy with you?
Written note, yeah, I have.
The same date chart that is available with you. If you have got the copy, you can give it with us.
Yes.
This is a written submission.
Yes, my lord.
Your written submission is thicker than your writ petition.
Actually, a lot of judgments and copies. That's why little bit voluminous. Otherwise, if you can stop.
What are the issues framed by the learned single judge for adjudication? One is about the maintainability of the writ, and the second one is your main payer. So on the maintainability, it has been held that it is maintainable.
Maintainability in regard, actually, that was the issue of in the earlier petition. Actually,
No. This, if see the order which you are challenging here,
Yeah.
Annexure 38. It also says that the writ petition was contested fastly on the ground that opposite party number 1 was not amenable to the writ jurisdiction, KIT University. So, and next it is stated that about the other thing, that the condition of appointment is so and so, so and so. So,
regarding jurisdiction, British Honorable Court, that was the earlier petition, that is 17171. That was
Mrs. Rotha, anything was adjudicated in this writ petition regarding that maintainability?
No, that's the first writ petition had the issue of maintainability.
This is not.
That is being reflected again in that. Like that judgment is discussing.
But there is no discussion in this judgment regarding that maintenance.
No issues were raised.
So, okay. So let us go straight to that.
Come to 471 page, para 26, 3D of the impugn order. Let us understand what is the order is. 471, para 26. You got it?
Yes.
Yeah, please read it. Let us understand what the parent single judge is. In the light of the above settled position, yes.
In the light above settled position of law, as we find with the ratio of decision referred to and discussed as above, in the instant case, it is seen that on rejoining of petitioner, he has been specifically apprised of the fact that he has to perform and discharge his duties for the residual period of probation being indicated herein satisfactorily. This was by office order dated 16th October 2014. By further order dated 3rd November 2014, the petitioner has been informed about his absence from the duty and not adherence to the standing orders in the matter and having nexus with the maintenance of general discipline in the institution. Though explanation to that effect has been sought for, no further action based on that has been taken. It is thus seen to have remained at that stage of informing the petitioner to take care of those aspects and further act accordingly. The final order of termination that has been made on 22nd November runs as under. The period of probation of Dr. U.K. Samanta, appointed as assistant professor on probation in the School of Biotechnology, KIT University, is due to end on 23rd November 2014. The question of satisfactory completion of the probation by Dr. U.K. Samanta has been assessed through an independent appraisal committee. The university decides not to continue employment of Dr. U.K. Samanta, the assistant professor on probation in School of Biotechnology, beyond the period of probation scheduled to end on 23rd 11/2014. As a result, his employment under the KIT University comes to an end with effect from afternoon of 23rd November 2014.
Yes, continue. The above order appears.
The above order appears to have been passed in relation to and keeping confined to the satisfactory completion of service of petitioner as probation, which is said to have been assessed by independent appraisal committee, as ultimately also coming to be accepted by opposite party number 1 without setting any different tone. There remains no such hint to the objectionable or blameworthy conduct. Undoubtedly, no inquiry at any given point of time has been conducted, specifically with regard to the fact stated under Annexure 16 and 21 or the office order dated 3rd November 2014, 15 November 2014, respectively. The narration in those office orders touching the duty of the petitioner are to be having their foundation and fact as available on official record coming to be maintained in regular course.
the tone and tenor of lengthy response of the petitioner to the above of his orders being cumulatively viewed to go to indicate that it is the petitioner who, instead of keeping the matter confined to the very subject, has rather stated such other matter also in writing issues unrelated to those narration in the order. The opposite party number 1 having sought for explanation has not further proceeded in those matter by initiating any proceeding and in causing inquiry for recording any finding on those scores. So here the ground for the termination now is found to have been based on performance of the petitioner during the period having no such punitive flavor in cause or consequence. Thus, the present case falls short of test laid down with approval in Radheshyam Gupta and Shukra. There remains so material to indicate that the same is based on satisfaction of any such misconduct. The opposite party number 1 in any event has not adopted the course of holding an inquiry and has also not proceeded to terminate by recording the ground from any other proceeding. It thus does not appear to be a case based on misconduct being attached to the petitioner having live nexus termination, merely because this order of termination under 25 Annex 25 has come out sometime after rejoining of the petitioner being successful in the application filed by him and by virtue of the order of this court, which is in fact and circumstances and earlier finding is obvious and not available in view of order of appointment stating for confirmation and regularization. No such inference can be drawn that the present order of termination is found open to those allegations which rather have been left at that stage without further investigation, touching the question of guilt or otherwise of the petitioner. Further, this order of termination is found to have recorded no such injurious reason, so as to say that the petitioner has consequentially been visited with any stigma getting so attached to the rest of his career, so as to lead this court to hold the order to be punitive. In view of the above discussion and reading the submission of learned senior counsel for the petitioner, that impugned order being based on those allegations and relating to those misconduct on the part of petitioner, squarely portraying him as blameworthy and the such stigmatic is not acceptable. In the wake of aforesaid, the writ application stand dismissed. However, there is no fact uncircumstantial. There shall be no cost as to order. Now, point is that
three things are emanating from this. One is you are in a provisioner. Your performance is not satisfactory, therefore termination order visited you.
I'm coming to that point.
Second is there is no stigmatic order pass because you have in reply raised many issues which has not been adverted to by the department. They have brushed aside that. Had they started an inquiry, then stigma would have been visited you. There is no stigma. So what is wrong in it?
Stigma comes months later. My joining out of many law points, I have trained many law points, and out of main law point is that point of law is that
Mr. Saman, when an honorable judge is putting something before you, listen carefully and thereafter try to answer. Don't interfere when the judge is making a submission. Right?
Yes, my lord. Yes,
that
my
is
lord.
the main thing which you should keep in mind.
Yes.
My esteemed brother is putting that this is the issue.
Yes, my
You
lord.
started interfering from the very beginning. This is not expected from either a counsel or from a client who is arguing his case. Right?
This is my question.
First, listen what the judge wants to know from you.
Yes.
Right? So now you can answer. Yes. So you have read the office order that is quoted in page number 31. You just read it out that paragraph?
Yeah, that office order.
Is there anything that the authority decided not to continue in the employment on the ground of your misconduct?
I'm talking about this order.
This order, yes. This
Yeah. The period of probation of Dr. Uttam Kumar Samatha as the assistant professor on probation in the School of Biotechnology, Tate University, is due to end on 23rd November 2014. So I joined in the Tate University in 28 July 2010. So probationary period is 1 year. So as per the order of the earlier petition, my service in the respondent university is deemed to be continuing for the entire period. So according to their official appointment letter, 1 year probationary period has already been completed by July 27, 2011. Following July 28 to 28 September, 28 July 2011, my service is supposed to be regular service in the respondent university. But they imposed the probationary period when I joined the respondent university following the order of this honorable court in the earlier petition. So I'm not a probationer.
What was that?
I'm not a probationer. I'm a regular service.
What was the order that was passed in your earlier writ petition?
Yes, that's what I
come to
the point of the page number. Page number 102. When I filed the writ application before this honorable court being agreed by the decision of the
102.
102.
It is annexure 10.
Annexure 10.
Annexure 10 starts at page number 89.
89, but I'm trying to not show everything. I'm just trying to show the page number 18. Page number 102.
102.
Yes. So when I filed the writ application before your this honorable court, so there are 3 questions mainly raised by this honorable court. That para number 13, it says whether the opposite party number 1 university is a state and or authority under the Article 12 of the Constitution of India and is thus amenable in this to this court. Whether the order of termination of Annexure 4 require an inquiry with opportunity of showing cause to the victim before the order of termination was passed, and as such, Annexure 4 suffers on account of violation of principle of natural justice. Third point raised by this honorable court was whether the order of termination of Annexure 1 attached any stigma affecting all through the life of the petitioner, and for affecting fundamental right of a person, a writ can be enforceable under Article 226 of the Constitution of India. So these are the things, these 3 questions are taken into account, and from submission of both sides, so honorable court decide the matter. And now you will also kindly come to the page number 160. 160.
60.
Of the writ application.
Yes.
Oh no, writ appeal.
Yes. Writ appeal, no?
Writ appeal 160.
That is
the first paragraph.
That is the judgment passed in the first writ petition.
In the first paragraph, second line, it is not only a deemed university under Section 3 of UGC Act 1956, but it has been declared to be an university under notification of the central government, followed with a gazette notification by the central government. So that was the observation of this honorable court.
What about the other?
You will also kindly come to the page number 60, 162. Page number 162 is the writ appeal. Second paragraph. Thus, while answering the point number 1 in affirmative, I declared that
opposite party number 1 university being a creature of a statute and since performing public.
Okay, that's not important.
That is not important.
That's the point. So this is under article
Page
12.
25. Page para
So now
25.
paragraph is 25. Yes, my lord.
Coming to the answer.
Now coming to the answer on the point number 2, fact as pointed out demonstrate that the university initiated an in-house inquiry against the petitioner and the said in-house committee admittedly holding an inquiry behind the back of the petitioner appeared to have right against the petitioner. While annexer CY1 recommended the authority not to extend the petitioner's provision and its authority claimed that.
Right, we followed it. Come to 164. 164.
Yeah.
That last paragraph, the last paragraph of that paragraph number 25.
Under the above fact.
Under the above facts.
Under the above fact,
right.
Fact ruling and any of the settled law that there cannot be termination dismissal order in absence of compliance of principle of natural justice. Thus, point number 2 also answered against the opposite party university holding the action of the university in terminating the service of the petitioner in absence of compliance of natural justice as bad and unsustainable. Yes. Then we will also come to the para number 26. Now coming to the answer to the point number answer on point number 3, I find that the service of the petitioner was terminated by the order dated 20th June 2011 as appearing annexer 4 at annexer 4. Though the said order did not attach any stigma, but while answering to the pleading of the petitioner, the opposite party number 1 to 4 in their counter affidavit submitted that before the order of termination by annexer 1 was passed, the case of petitioner was being examined by an in-house inquiry committee who had an unanimous opinion that conduct of Dr. Uttam Kumar Samanto, the petitioner, has not been satisfactory and is highly unbecoming of a responsible faculty member of the university as clearly appearing at annexer C/1. It is based on such report his service was terminated by annexer 4. Thus, in my considered opinion, even though the order of termination did not attach any stigma, yet in view of finding of the inquiry committee as appearing at annexer C/1 with the strengthening of right to enforce act and transparency in the action of actions, the future of petitioner is very much likely to be jeopardized. As such, after coming to the above finding, which finding was arrived at by an internal inquiry committee held behind the back of the petitioner, law minimum requires compliance from natural justice by at least affording an opportunity to petitioner before issuing the termination order right answer 4 for this termination right or order right answer 4 cannot be sustained in the eye of law. My view to get support of the Honorable Apex Court decision such and such where in para 7 the Honorable Court held that the order of termination attaching stigma needs compulsory compliance of principle natural justice. Under the circumstances, I answer point number 3 and also in favor of the petitioner and against the opposite party. Now your lordship kindly come to the para number 27. In view of my finding on point number 1, right, paragraph 22, 23, and 24, my finding on point number 2 at para number 25, and my finding on point number 3 at para 26, while answering the petition, I set aside impugned order at annexer 4 of the petition as well as the consequential orders as appearing at annexer 4 of the petition. I further declare that petitioner whose service has been taken away by the order under annexer 4 be deemed to be continuing in service for the entire period. But since he has not worked for all this period, he may be paid 60% of back wages. So far, petitioner prayer for direction to the opposite party number 4 for supplying documents mentioned in the annexer 2 documents at internal page 25 filed by annexer 12 series the supplementary affidavit at the instance of the petitioner. It appears
Kid University has already brought it under the fold of Right to Information Act, as Judicial Information Rules 2005, and the petitioner is at liberty to place into service the provisions of the Right to Information Act 2005 for the said purpose. However, these judgments shall not preclude opposite party number 1 university to restart proceeding against the petitioner or to conclude lawfully. I also make it clear that this court has not expressed any opinion on the merit on the allegation against the petitioner.
So, after this judgment was passed, whether the university has restarted any proceeding against you?
They, whatever the office letter, before termination letter, they issued several office orders.
We are asking you a pertinent question.
Yeah.
They have not started.
No, they started appraisal committee instead of inquiry committee, and that appraisal committee also in the back door of me without my knowledge. And based on the appraisal committee,
we are asking you: have you
received any notice?
Any notice has been received by you in connection with a phrase disciplinary proceeding against you?
No.
No. So the matter ends there. Yes. Now when after this order, they issued any phrase order, you joined, they allowed you to join?
Yes, my lord.
What is that joining letter?
I have
after this judgment was pronounced, what is that joining letter?
Their office order.
Yes, yes.
Yeah, I submitted a joining letter on October 9, page number 167. And after that, I gave them a reminder on October 25th. Oh, sorry, pardon me, October 15, followed by which they sent me the office order dated October 16, number 172. And that was sent to me, although it was October 16, they sent me by email on October 18.
Okay, so what is that office order?
It says that the report of rejoining of dated October 9, 2014, submitted by Dr. Uttam Kumar Samanto after delivery of the judgment dated 29 September 2014 by the Honorable Orissa High Court in writ petition number 17171 of 2011 filed by him against the Kid University and others challenging termination of his employment is accepted with effect from 16 October 2014. In pursuance of the said judgment, acceptance of joining report is subject to the following. Provision of Dr. Uttam Kumar, Dr. UK Samanto has been disrupted by intervention period from 20 June 2011 till this date, and so 1 month of 7 days out of provision period of 1 year still left out to be completed. Rejoining of point number 2, rejoining of Dr. UK Samanto would be accordingly on provision to be completed after 1 month and 7 days, that is 23rd November 2014. Point number 3, University reserves the right to initiate disciplinary proceeding against Dr. UK Samanto on previous allegations as per the observation in the judgment.
So that matter they have not initiated, matter ends there. So in pursuance of
number 1 and 2, yeah, point number 1 and 2.
Again, you started the same thing. Please have patience. We are hearing you with all patience. So when this order was passed and they allowed you to join, and they said that some period of the provision is there to be completed, and so you joined.
I joined.
And no disciplinary proceeding was initiated.
No disciplinary proceeding is not.
So after you completed the provision period, what orders were passed by them? This period, the 1 month and 7 days, that was left out to be for that provision period. That is the order.
That is the order. That's my point. I challenge this office order also, stating that this imposition of provision period
did you challenge this order dated 16/10/24?
Yes, my lord.
In any writ petition?
Yes, my lord.
In which writ petition?
23250.
When have you joined, by the way? After this letter, 16/10/2000.
After termination, when after second time termination, this terminated me just just immediately after the order of the previous read application order.
No. I'm asking something else. After 16/10/2014 letter asking you to join, when have you joined? Date. When have you joined? Joined back.
I submitted my join before this. I submitted them. Kindly allow me. I submitted my joining letter to them on 9th October. They issued this joining letter accepting the order with the Honorable Court on 16th October.
Yes.
And I receiving this order on 18th, and they did not say anything about the back wages and anything. I've been waiting. The accommodation, sitting place, and
okay. When have you joined? That's nothing. Answer it.
So did you join?
Join or
question is
then I went there and submitted. As I said, 9th October already I submitted joining to them.
See why I am asking this question is
then on October
it says that you are remaining 7 days, 1 month, 7 days probation period is still remain. So that will occur the day we joined. When you joined. From there, 1 month, 6 days, 7 days will be counted. When you joined, give the date.
Did you join?
I submitted my joining, my lord. I submitted my joining on 9th October following the order of this.
So you mean to say that if you send a joining letter?
No. Following this office letter, I reported my joining there on 5th November.
That you say
5th November you joined.
5th November.
Yes.
Okay. Then what happened after 5th November?
5th November, when I joined then actually I did not know anything. No accommodation was given me, no sitting place was given me there, no assignment of work and duty was given to me, no office order was there to settle each and everything. But they generated one more office order that is on November 3rd, which I did not know about that. And there they started blaming me and accusing me, and also brought the new allegation of misconduct in addition to the old allegation. So that office order also we have challenged in the next application. So I'm telling about 3rd November. Page number 195 of the read appeal.
You've come to that 195 which you are relying upon.
Actually, it is their office order.
That is Annexure 7, right?
Yeah.
They are what you have there. They have mentioned in the that seconds of paragraph, or it would be first, second, third paragraph, you see. Annexure 17.
Yeah.
Dated 3rd November 2014, office order of the Kyoto University. What they have stated.
Second paragraph is said, Dr. Yuka Samanta.
No, that's third. It has come.
It has come to notice of the university that Dr. Samanta has not been going to the School of Ethnology or reporting for duty before the director of school and taking instruction regarding his duties from the director right from the day one since 9th October 2014 when he submitted his report of joining, or at least since 16/10/2014 when the order of the said date was passed by the registrar accepting his rejoining report. Now here, my lord, they said 16/10, at least 16/10 of 2014, but 16/10 later I received on 18/10, so they cannot claim 16/10. And such date they have specified everything arbitrarily. In addition to that,
16/10 order you just placed, that is Annexure 13, and you said that there is no order on 16/10/24.
I received on 18.
What is the order dated 16/10? That is what exactly it has been mentioned that let us say the order is dated 16/10/2014, but you received it on 18/10/2014. But in spite of that, you did not join the duty, though you submitted a joining report way back on, let us say, 9/10/2014. So the question is that period which they want you, the rest of the period, that is 1 month and some days, So, that is the probation period that was left out to be completed.
That provision period is illegal, my lord.
One thing, if a person is on probation and the authority feels, let us say after the period of probation, that the performance of the petition, the employee is not satisfactory. So, are they bound to give you to regularize you?
Bound to start inquiry and do everything is not required.
I'm coming to that one. Following the order of the of this honorable court in the earlier application, which was discussed on 29th September 2014, my joining in the respondent university is a regular service. They misinterpreted the order of this honorable court. Also, they ignored the statutory rules regulation.
You see, that letter which has been issued to you.
No, that was in violation of the law.
No, have you challenged it?
Yes, my lord.
Where have you challenged?
I challenged in the writ application, the 23250. 23250. I just a moment.
What is that?
I challenged that.
No. This after the order was passed, when they issued that letter, office order dated 16/10/2024, in which you are allowed to complete the left out probation period. So, did you challenge this office order dated 16/10/2014?
Yes, my lord.
Which writ petition?
Writ petition.
This presently.
Kindly come to the page number 2 to 4 of the writ appeal. And in the writ appeal,
he is emphasizing this word,
page number 27.
Deemed to be continuing in service for the entire period. But since he has not been working for such a period, for 60% salary,
that is supervisor.
Deemed to be continuing service means what he meant to say is a continuing service.
But in spite of that, the order has been passed and that he has challenged also in the writ petition WPC number 23250 of 2014.
Mr. Rotha, how many years probation you generally give?
1 year.
How many years? 1 year.
Yeah, just no, that
Extendable.
wages are different. In his appointment letter, there was no maximum time. As far as the UGC guideline was there, the probation has to be for 1 year. So he was his discontinuation was before that 1 year. And then the UGC guideline says that you can extend it for another 1 year. However, his confirmation will require an assessment and thereafter you will take a decision. So there was no deemed confirmation system, and that's also the finding of the single judge. The judgment is there. So therefore, there was no deemed confirmation system, and the letter of appointment did not restrict our powers to how many years we
can. The question is, when you terminated him second time, which was subject matter in the last writ petition, whether the probation period was continuing.
It was continuing. Why?
If that period, see, in the earlier round, it was said that the period will be taken its continuing period. If the continuing period, then the probation period is over.
No, I would say, Lachus. In fact, there are a lot of facts which have not been.
Where from you got that 1 month, 7 days?
No, I would say that he was terminated exactly 1 month before his probation period got over.
Yes. 1 month, 7 days.
1 month.
Yes, 1 month sentence. And only, so the prayer he made was setting aside of that termination order.
Right.
So once a termination order goes, he goes back to the place he was. So he went to the place of probation. As far as the consequential service benefits was concerned, the court only said that I am giving you a continuation only for the back wages. So that was also the finding of the single judge. And single judge also, just like a lordship's raised, also has dealt what was the law of probation. So even if I say, even if whatever interpretation is done of the earlier order, if a deemed confirmation is not the position emanating from the rules, so he cannot claim whatever the length may be, because the deemed confirmation, according to the analysis of judgment and the rules, required a positive act on the side of the university.
Supposing you don't pass any order
No.
for years to come,
Yes,
it is deemed to be, the probation period is deemed to be extended.
Lordships, there are 3 sets of, in fact, there's a very important judgment of the Supreme Court which says there are 3 sets of scenario as far as probation is concerned. It's very beautiful judgment.
Yes, you just answer that.
It says,
suppose the authority don't pass any order confirming a employee.
Yes, Your Lordship.
And not even extending the probation.
It will all depend
and the probation is deemed to be extended.
Your Lordship, the law is that the court will probably have to first see the rules and then see in which 3 scenario it falls. Suppose there is a language that it is that if you don't extend it is automatic, then it will be automatic. Suppose there is no restriction on your power of how many years you can go, then we will see whether it is automatic or not. We can analyze that. On third occasion is, if it requires a positive act like of an assessment, then unless that order does not come, he is deemed to continue, but not deemed to continue in probation, but not deemed. That's the law, Your Lordships. And
notwithstanding the fact that the statute says 1 year.
Lordships, I will say exactly it is not that way. UGC says something else. I'll come to that. In fact, everything has been analyzed in that judgment. I will also show everything.
We'll go to that. We just want to a factual clarification.
Yes.
That after the this order was passed on allowing you to join, that is the order dated which you just placed, that is I think 16/10/2014, which you say Mr. Samant you challenged in a writ petition. What happened to that writ petition?
My lord?
You said that you challenged the office order dated 16/10/2014.
Yeah, my lord, that is the point. Page number 227 of the writ application I said. In the matter, an application challenging the aftermath actions of opposite parties, Kid University, after the disposal of writ petition number 17171 of 2011 on 29/9/2014 in issuing the office order number such and such dated 16/10/2014, later such and such.
What happened? What is the result of this writ petition? 23250 of 2014, in which you have challenged that office order dated that 16/10/2014, whether it is pending or disposed of.
Yeah, that writ petition is pending. That's why this writ appeal is before our lordships.
May I clarify?
Just a minute. Ocha, this writ appeal arises out of this 23250.
Yes,
Okay.
We challenged it after termination.
Okay.
Yes.
So
that's why I challenge in the writ petition. I challenged all their office orders, including the final termination order. And
now what order was passed by in this writ petition, which you are challenging in the writ appeal?
That's what
I
I have read out in the morning.
Just go to that, because there are so many annexures, so it will take just come to that operative part of the impugned order passed in this WPC number 23250 of 2014.
Yes, my lord. Before that, may I get permission, your lordship, to say something about statutory rule EGC?
Please come to that order.
Let us clarify.
Just please come to that order. Then you.
Okay.
advance your argument. We are not restricting you. Just come to the order which has been passed in this writ petition, which is under challenge in the writ appeal.
Your Lordship, 471, para number 26.
470.
I'm reading.
471.
471, yeah. Yes.
Okay, okay.
Para 26.
Para 26. Okay, this, oh, just replace that. No, we followed it. No. That was the question which we are putting to you. Okay. So now you answer. So what is the what is wrong in the order of the land single judge, which you are challenging?
Important thing is that the respondent universally imposed provisional period upon me in the time of my regular service.
Oh, are you aware about the scope of a writ appeal?
Yes, my lord.
What is that? Interference with the order of the land and single judge in a writ appeal. What is the scope? Because you are arguing in person, that is why you must know it, that this is my scope. I cannot argue as such. You are to put your case within that situation, that this is my scope, and if I bring my case within this, then I will succeed in the writ appeal. Otherwise, just show us, if you are ready, that this is the scope of interference in a writ appeal.
Honorable single judge passed the order.
No, you are going to the factual aspects. We are asking you, are you aware the law settled by this court and by the Honorable Supreme Court regarding the scope of interference in a writ appeal against the order passed by the land single judge? If you do not know, then you will argue like that as if you are arguing a writ petition.
No,
that is not permissible.
Yes, my lord. If honorable single judge made a mistake, not considering the point of law or rule of law or constitutional provisions which is available to me, then I can approach before.
Which is the citation? Let us see how you have studied it.
Mr. Samantha, you must understand one thing. You are a teacher. Okay. Except teaching, you do everything. And you're trying to argue a appeal. The scope is very limited. Why don't you engage a lawyer? Why are you taking that risk of arguing without knowing the law?
Actually,
it's not your classroom, which you are supposed to teach there, you didn't teach there.
Since I have missed my lawyer, so I'm trying to present myself to satisfy.
You are a lawyer?
No.
Then have you done LLB? You better start practicing legal teachership.
You see what is the problem? The problem is that if you do not know where to hit, you will just hit here and there.
Then
right? If you know the law, that my scope is very limited in this writ appeal, and if I will bring my case within this scope or this purview, then I will win the case. Otherwise, if you will go beyond that, then that will be irrelevant, because we cannot consider those aspects in a writ appeal. That is why exactly we are asking you with all patience, we are listening you. Just please know that what is the scope of interference in a writ appeal against the order of the land and single judge. If you are ready, if you have citations, please show us and apprise us that yes, my case also falls within that. So it is a case to interfere with the order of the land and single judge.
Exactly.
That is the problem. My esteemed brother is asking you that you are not aware. Please engage a counsel. And if you want legal aid help also, there are so many counsels who are practicing in service matters. They are in the panel. You are not to pay single money pie for that.
What will happen is you keep on arguing for days together, you will not reach anywhere.
That the point, the scope, if we do not know, you will just beat the bush here and there. Are you following us?
You want a lawyer, then we can very well request someone. We can, or if you want to argue, nobody can stop you. We can argue.
We are not stopping. You are just, we have heard, you have given you almost 1 hour time till now. We are hearing you. But the problem is that we cannot hear it as like a writ code. The observation, unless we find that there is any perversity, unless we find that the material part of the documents or thing has been left out, which would have been considered, the result would have been otherwise. If that is why we are asking you that you know that what is my scope of.
As Honorable Single Bench, Single Judge did not consider the statutory UGC, that is fundamental point. But passed the order.
Which is going to that. You do not know the law. That is why the problem arises.
The judgment he cited North 11.
Have you cited in your written note of argument, have you cited any judgment regarding the scope of interference in a writ appeal?
In the particular language, may not be.
We are ready to give you time. You now, if you want to argue in spite of our all whatever, you can search for decisions also, right? And you bring your case within that purview.
Yeah. Since I'm agreed by the decision of the Honorable Single Bench, and at what point?
If you see so many matters have been listed, so many counsel are waiting, and since you are appearing in person, we are giving you time. Otherwise, you will say that I have not been given opportunity of hearing, sufficient opportunity of hearing. Sufficient opportunity of hearing does not mean that host would waste the valuable time and hear whatever things has been argued. We can restrict you, because if you go beyond that scope, we'll say that Mr. Samant, you cannot argue this matter because it is beyond the scope of entertaining a writ appeal. So that is why we are again telling you that know your scope and prepare accordingly, so that the argument would be appreciated in a better manner. Right?
Because you are taking the plea of mala fide and all that, you can't take in an appeal.
No, I can prove that.
For the if you are pleading mala fide, then against whom you are pleading mala fide?
We cannot take it. Those things which are not been argued in the writ petition, opportunity has not been given to the opposite party to have their say in the counter affidavit. If you raise those points for the first time in writ appeal, we cannot take into consideration. That is why we are telling you that know your scope, right? Go know the scope, know the law, and prepare your case accordingly. So hit at the point so that you may succeed. That's up to the final adjudication. That's a different matter. So tell us a date so that we can take
the call. Either you engage a counsel or prepare yourself well, and don't take us here and there. Focus on the point within the permissible limit of the jurisdiction of this court in an appeal. Beyond that, don't travel. Then only you can succeed. Or otherwise, you can't understand, then engage someone. Or if you can't engage someone, tell us so that we can engage someone. Something of that sort. Okay? Don't waste your time. Yes.
Tell us a date so that we can.
Can we fix a date?
No.
You tell us.
You tell us.
Which will suit you.
We are here. You tell us. You are appearing in person. You are to get prepared yourself. You are to read the law. You tell us the date, and the learned senior advocate is there. Of course, her convenience has also to be seen, and we'll fast a date on your the convenience of both of you.
Maybe next week, my lord.
10 days after.
We are giving you 10 days time. You tell us any date after 14. Leave Tuesday and
It will be
Thursday.
18 or 22nd.
Tuesday and Thursday, that's a separate bench is there. Leave those
20?
days.
22nd.
22nd.
22nd. So 22nd
Friday,
again, that is
Friday.
Tuesday.
21st.
Monday,
Wednesday,
Wednesday and Friday.
Okay.
Because of the other bench is there, so that is why the problem is there. So tell us a date. 21st we'll do.
21st.
22nd minor.
22nd, no, 22nd. Yeah.
मंगलवार आउ गुरुवार छाड़िकिनी आपण अन्य बार कथा कहतु 23rd. After arguing for some time, Mr. Shamant in person, seeks for an adjournment to cite some case laws on the scope of interference in a writ appeal against the order passed by the land single judge. Yes. And for further preparation. The land senior advocate, Mrs. Rothholm, is present on behalf of the respondent university. On consensus of both the parties, lists this matter on 23rd July 2025.
In this case, I have an opinion number 5.
Please give the name so that we can mention. Once is appearing for opposite party number 5. Yes.
Item 12.
I appear for the petition, I lost. Item 12.
You are appearing for whom?
For the petition, I lost.
Who is appearing for the OSFC?
I am Mr. Mahanti.
Please, sir. Just wait, let him. Here. What is this matter?
Matter is about, my lord, my late father he owned a property which was mortgaged to OSFC. That was the leasehold property. Vivek in 1985, lease was sanctioned in his favor. And subsequently, the unit came to be seized by the corporation in exercise of power under section 29 of the SFCF because of default in payment. It was taken over. It was auctioned. So after that one, unit was put into possession and that unit also defaulted. Therefore, another auction was there. At that time, the offer came to about 90 lakhs. I challenged that before this Honorable Court in 2009. This Honorable Court said that, okay, you improve your offer so that we will see and protect your interest because you were the original borrowers, my lord, legally. So that being happened, I offered 1 crore. It was accepted in the court directed that you pay 1 crore. They'll return the money of the auction purchaser, whatever initial money they had accepted, which subsequently happened also. They returned the money. And the property may be settled in my favor. It was not done. I again.
Not done means you did not deposit the money.
I deposited in 2014.
That 1 crore you deposited.
I deposited.
Yeah.
But things did not materialize because certain other issues also cropped up. I'll cut to that. Then in 2016 or so, I came before your lordship in a writ petition. Your lordship passed an elaborate order saying that, okay, that 1 crore is with you. Whatever balance amount is there, he will file a settlement application, one-time application. You consider that. And you give the property to the petitioner. My mother was the petitioner, then she died in the meantime. So that was not done, my lord, for which the contempt was filed. Then things moved on, but it did not materialize, so my amount remained with them for all these days. Thereafter, I approached this Honorable Court in another petition, where this Honorable Court directed that since he has already paid 1 crore rupees and you are holding the money, how much he should pay so that he can settle it. They came up and said that 47 lakhs is the balance amount if they can pay. It will be delivered to them. So I offered to pay, but the courts directed me to go for a settlement with them. So I went for a settlement with them, called for a meeting and all that. In the meeting, first time they raised in 2023 that it cannot be done because it is a gochor land. So that is how we are hanging since 2023.
Where is the order dated 19/4/2023 of the High Court? 2023. Where is that order? See the prayer. See the prayer.
In this petition.
The prayer could be.
That your lordship would find in this writ petition, it's order number 4.
See, in the prayer, if you see, there are two prayers. One prayer is you are seeking 10 crores of rupees as compensation and other compensation, which could only be decided by a suit court. Okay?
It was there.
And next is enforcement of one order passed by this court. That also could be done through contempt and all. These are the two prayers. In the writ petition, what we can give you?
Your lordship will modulate that.
No, 14/9/2023, you are asking to quash it. What is that order? That 14/9/23?
14/9.
14/9.
Act of in the order. 14/9.
14/9 APS at page.
Where is that order?
37.
37.
Okay.
What was the order? Where is the order? Where is that order?
It is not the order, it's just I think it's a
letter. Yes.
So why we pass it?
No, I'm sorry.
It is your letter to the managing director OSFC, and why will quash your letter?
No, I'm sorry.
Are it upon prayer করছেন না?
Prayer B.
35, sir.
No, prayer B.
35.
Prayer
14/9/21.
B. As to why, OSFC so shall not be directed to act upon the order dated 14/4/2000 of the Honorable Court passed by this. Where is that order?
But 19/4/23.
19/4/20.
19/4/23 by content file করছেন.
Where is that order? 19/4.
Against the order dated 19/4/23, any content petition has been filed.
Thereafter, lordship, no.
No. If an order has been passed in your favor on 19/4/2023, which according to you, the OSFC has not complied, so why a second writ petition would be entertained for the self-same
This came by amendment, your lordship.
What is that order? Let us see. What was the direction?
Look at order number 4 in this case.
No, you show us the annexure. 19/4/2023 passed by this court.
I have filed that.
Where is that?
In my compliance affidavit.
You are praying that you have not filed that.
It is there on record. Possibly that's why it is not filed.
I have filed it in my compliance affidavit.
Where is that?
That is a page number. Annexure 1 লেখা আছে compliance affidavit.
Yes.
Compliance affidavit on behalf of the opposite party 137, 140. It is 141 page.
141.
Right.
Okay. What was the direction?
Hard SK, Mr. SK Mishra and counsel for the petition and Mr. D.N. Mantin and counsel for
come to para 5.
5.
Yes.
In view of the matter, since the petitioner is willing to have settled the matter on compromise, let the petitioner approach the corporation to settle the matter in accordance with law with an opposite party corporation to take necessary steps to accept the suggestion given by the petitioner as to get some money from the petitioner and close the matter all time to come.
Do it.
No, that is what I did. Your lordship may look at paragraph 3 first of that order. Learned counsel for the petitioner contended that the petitioner had deposited ₹1 crore pursuant to the order passed by the court, but the same was retained by the opposite party. The petitioner is now willing to deposit 1 crore 47 lakhs, 47,000 as has been suggested by the opposite parties. The money which was refunded by the corporation of the petitioner, that had also been deposited with the petitioner with the corporation since June 2015. Mr. Mahantin and counsel for the OSFC contended that the amount which was returned back to the petitioner has also been resubmitted with the petitioner with OSFC and be kept in account of the corporation. Here I said about the money, I had deposited cash with them, so they returned a check which was never in cash, rather it was returned to them. So this is the order passed on 19/4/2023. Now they asked me for a settlement. because the court said that you go for a settlement. I approached them. They called for a meeting, my lords.
What happened?
That meetings, first time they came up with the plea that your lordship would find at page 154. The relevant portion is
154.
156. Your lordship may look at 156.
Of your writ petition?
Of the writ petition.
That consolidated writ petition?
Yes, your lordship. Page 156. My lord, thank you. Mr. Satyakam Mahapatra was present on call. He requested before the committee to release the unit of such and such mechanism on further payment of 43,47,389 because in the meantime I had already paid 3 lakhs some further money with due demarcation, issue of non-due certificate and sale certificate. He is also further requested to release the original land and mortgage documents in his favor without further delay or else compensate him sufficiently. The committee pursued the memorandum and discussed the entire background of the case in detail. It was appraised to Sri Mahapatra that the mortgage property is a communal land recorded as Gochoro and therefore restriction is imposed by the district administration Khurda not to put the mortgage land into auction. However, OSFC has already invited the attention of MSME department, revenue department, seeking their views so as to comply the direction of the Honorable High Court of Orissa. The constraint of OSFC was also appraised to Sri Mahapatra along with the relevant records. After elaborate discussion, the committee suggested to Sri Mahapatra to wait till a response is received from the MSME department, revenue department and government of Orissa, since the lease land is kosher has been vested to government khata as Gochoro and not transferable at this stage. It was also decided that the steps taken in the corporation in this regard be informed to the Honorable High Court of Orissa through our penal advocate. So this is remained as such. Thereafter, there is a communication dated 12/7/2023 dated by the next page. That is dated 12/7 to the managing director of this government rights. In inviting reference to a letter number such and such on the subject cited above, I am directed to say that since the land mortgage is a leasehold land bearing khata number such and such, area such and such, and has been categorized as communal land Gochoro, hence OSFC should surrender it to the state government and return money received by, if any, from that is myself, my mother, Prabhatanarani Mahapatra. So this is how that was their stand. Now in this connection, it was mortgaged since 85. Changed 3 hands. It was put up for auction after getting permission from the government. For that, I am taking a lordship to 2012 communication between the government, the corporation, that my lord would find at page number 111. This comes as a compliance affidavit to my friends OSFC's compliance affidavit, my lord. The lordship finds it.
No, if it was a Gochar land, then how did you set up an industry in that on that Gochar land?
That was since 85. This they have explained in these letters. Let me place that here also. This communication with the OSFC and the government, how they have dealt this matter. This issue was raised when the property was put up for auction in 2009. Their government objected to this because saying that this is a Gochar land, how can you go for a auction of the Gochar property? Now these are the communications and your lordship can be deal with you. This is government letter 111 to the corporation. I am to say that sale notice has been issued by the Orissa state such and such for auction of land occupied by NS mechanized bricks. Vidyadharpur from the ROR reveals that plot number such and such is a communal land recorded as Gochoro. It is not known as to how sale notice has been issued for auction of the government land.
Because once you have to take permission from the concerned authority for setting of an unit on the land, details must have been furnished.
Yes.
And there must be also column which would show that what is the isham of the land. So if you would have mentioned that it is a Gochar land, obviously they would not have given you permission to set up an unit in that butcher
No,
land.
here your lordship may appreciate one aspect to it. This was a leasehold land granted by the government for setting up an industry in an industrial area. That is your lordship, page 112.
So what exactly you want from this court now?
I want to pay this 47 lakhs and get the property, my lord.
Which property? Same Gochak land?
Yes.
What you will do? You cannot run the industries there.
I can. That is why I am taking your lordship, taking the trouble of taking your lordship to page 112, 113 and 114. How the government decided that? No, in spite of the fact that it is...
Then what have you prayed in the writ petition?
Then I have to relook, my lord.
Because
we can't allow this.
the petitioner
is just moving in a very wrong direction, my lord. From the very beginning, my lord, the facts are very clear.
Let me let you place, then we will put the court into right direction.
Yes.
Please.
You are misleading.
Misleading. I am placing your
My
document.
lord,
as
originally the loan was sanctioned in favor of a private limited company of one Shiva mechanized brick, represented through its MD Guru Prasad Sitaram Brahma. That is a private limited company. They couldn't repay the loan, and the unit was taken over under Section 29 of the SFC Act as per the statute. Then it was handed over to NS Mechanized Brick, another company, and they also failed. That company also failed to repay. Thereafter, it was again seized and put to auction. During auction, the present petitioner didn't participate. Subsequently, she came. One housing corporation, they offered a price of 90 lakh. Then the petitioner approached this honorable court stating that it was my property. Shiva Mechanic, the first private limited company.
Yes.
So the honorable court directed to settle the matter as per OTS and all that. For OTS, my lord, there is a specific scheme. One has to furnish the transactions of the last 3 years and all these things. They couldn't do it. And from the register of company, when we inquired, the present petitioner's mother, who claims to be daughter or sister like that, her name was not there at all. And the company was defunct. She was no way connected with the first company. However, in order to comply your lordship's order, we have given a chance for OTS. And they couldn't comply the terms and conditions. OTS failed. Thereafter, we returned the money. They didn't receive it, they immediately sent it back. And again approved your lordship. Your lordship directed to consider the case again. So now the question is, my lord, how can we consider? It is a Gochar land and we have been restrained.
That is for the purpose of sale. You forget about the sale. Now settlement of the account. He is ready to pay the money.
Settlement, my lord, settlement of account, my lord, for area dues, for area. So, my lord, the honorable court has directed us to consider his case. What type of consideration we can make when we are not empowered to take a decision regarding alienation of land or transfer of land?
There are two aspects.
You have to apply the mind afresh and work out a OTS.
OTS, my lord, that
That was
opportunity was
decided, my lord. They said pay 1,47,000, 1 crore 47. I agree to that.
application of mind, my lord.
That all, just a moment.
When
did I misled, my lord? By
forget about that. When have you agreed? Which year?
Your court lordship directed in 19/4/2023.
So that
order. 19/4/2000.
Now what is the amount according to you?
That I will have to find out.
It will be in crores, my lord. It will be in crores. Question is not that. Now question is Gochara land, we can't pay, receive 47 lakhs.
It must be in crores, otherwise you would not have paid.
Yes.
No. I was there.
5 acres of land near the studio Bhubaneswar. 5 acres of land.
Something else now. My
5
question is
acres
why
of
it
land
came to your lordship
at
in
Bhubaneswar,
2019.
that too near that Kalinga studio. What would be the present valuation?
I came to this on
And that's why they have come.
No, that you were there in 2019.
Yes.
This order was
Yes.
passed on 23. What is submitting, my lord? This order on agreement. On both sides agreed to this.
No.
Who is eliciting whom I don't know. This order is deprotivized 19/4/2023. Learned counsel for the petitioner contended that the petitioner had deposited 1 crore pursuant to the order passed by this court. But the same was returned.
The problem is either you persuade us or he persuades us. The order would be, please consider. Beyond that, we can't do anything.
Your lordship can enforce the direct.
We can't issue mandamus.
My lord, there must be a scope for consideration. What we can consider.
Now it boils down to one thing.
Just a minute.
Last it boils down to one thing, my lord. If it is Gochara, whether it is a Gochara earlier or it has become Gochara overnight. That is what it is, my lord. In spite of all this, my
that
lord,
in the writ petition we can't decide.
No,
whether it is
that
Gochar land,
already,
it's not a Gochar land.
that they have already considered. At page 117, under the above circumstances, government rights to the corporation, to the government. Collector rights to the government. Under the above circumstances, is requested to place the matter before the government and communicate necessary orders for public auction of the said land by the government authority so that the action amount will be deposited in the government treasury after meeting the corporation's dues. This is clear.
That is the government. That decision who has taken. That way.
The decision who has taken. I have got nothing to say.
I have 3 points. 3 points. Apart from all these submissions,
so now it is too late. My humble submission is too late in the day to raise an objection because it is Gochara. We can't comply with your lordship.
Apart from that, my lord, I have got some other objection. Your lordship. Right to redeem. If accepting that he is the mortgage.
Beyond the scope of the writ petition, the prayer is something different, and you compel us to decide that Gochara land, all these things are different, totally different.
My lord, me grant me one.
He is seeking 10 crores compensation in the writ petition.
Your lordship may grant me.
Possibly didn't.
1 week time.
Didn't
I'll
take
look
back.
into the prayer.
Come to that.
My lord, my 3 points.
Question is Gochara cannot be an issue now. It was decided in 2011. It was there in 2014.
Have you completed? Have you completed?
No, I will come back to the order.
So that you remember it next time when you come, you satisfy the lord.
It is now.
3 points, my lord.
It is now time, and both of you just enjoy the cafeteria.
Cafeteria, my lord. That we will be doing.
Please go with the Lieutenant Senior at
3 points, my lord. Right to redemption is available till the mortgage property code.
That's the only relief today we can give.
Yes,
so we cannot finish it by.
But at the same time, you have to amend the writ petition. What is this?
I will have to.
The Mr. Sarangi Land Senior Advocate appearing for the writ petition seeks some time to amend the prayer made in the writ petition. Put up this matter on such and such date. Kebe kon rakhiya? Mr. Mark Land Senior Advocate is appearing for the OSFC लिख देवे. केबे रखियो फोन तो?
मंगलवार गुरुवार छाड़ी बरा.
हाँ मंगलवार गुरुवार छाड़ी.
हाँ 23 तारीख रो.
23 तारीख. This matter on 23rd July 2025. If an interim application is filed for amendment of the prayer, in the meantime, the same shall be placed on record. Copy of the interim application. This are one, Mr. Hanti.
There is a modification, my lord, for 25th, not 25th.
25th. Do it before you. From 3rd August, I will be absent for a month.
25th of this month.
Yes.
July, 25th July.
Yes.
Alright, keep it on.
August. In August, I may not be available.
No, it's alright. What is July?
And by the way, I'm asking my learned friend, where did I mislead?
Yes.
Both of you.
They are very loose.
That's why my brother said that. That's why my brother said that you go to cafeteria and decide it. Who has misled whom?
14, can it come day after tomorrow?
Yes, yes. Yes. प्रकाश बेहरा अनम्यूट करो कौन ना नंदकिशोर सेठी एडवोकेट बाबू अच्छी बसंत आप बसंत यस मिस्टर मूल्य तो
now it's start from exhibit 21, right?
exhibit
21. Page 295.
Just not that. So we have taken note that exhibit 21 is a seizure list which relates to the seizure of wearing apparels of appellant number 1. That is Prakash Behera alias Babuli. ठीक तो? Mr. Mulya?
Not 21.
Exhibit 21 available. नहीं, appellant number 1 रो seizure हमसे या तो पूछे होची.
Prakash Behera.
Prakash Behera परा? Appellant 1. हाँ, appellant number 1 Prakash Behera नहीं. And the one is that full shirt which has been marked as MO1 and one jean pant which has been marked as MO2. ठीक तो? ठीक है. And you said that only 2 witnesses are relevant for that seizure list. One is PW15, the other is the IO PW41. Is it correct?
Yes.
PW15 has supported the prosecution case.
128.
Now another thing. Anything was found in the that C report of these 2 material objects, full shirt और jean pant को किसी मिलिला और खाल्टा सीजर वाला कौन
The report of SF is circular.
हाँ देखा तो भी full shirt और jean pant को appellant number 1 रो किसी रक्त को मिली था जो रक्त की disease माने को सहित को connect ही पुथी वो ताले तार किसी से सीजर और किसी relevance है otherwise ना कोड के उठी मार्किंग.
The relevant portion is page 357, volume 2.
357.
357, volume 2.
ନାଇଁ ନମ୍ବରଟା ଦେଖାନ୍ତୁ ସେ ଯୋଉ ଫରୱାର୍ଡିଂ ରିପୋର୍ଟରେ। ଫରୱାର୍ଡିଂ ରିପୋର୍ଟରେ ସିରିଏଲ ନମ୍ବର କେତେ? ପ୍ରକାଶ ବେହେରା। ହଁ, ନମ୍ବର ହଉଛି 27 ଆଉ 28। ଫରୱାର୍ଡିଂ ରିପୋର୍ଟ ଦେଖନ୍ତୁ ସେଇ ଦିଟା ତ। Forwarding report, page number 345, serial number 27 होची तारो full pant, आउ serial number 28 होची तारो full shirt. Now that as one is marked as exhibit P, the other is marked as exhibit P1. Mr. Tripathi, ठीक तो? वर्तमान P और P1 रो ये एनालिसिस रिपोर्ट कौन आसला देखते हैं। फूड पाइले तादर किसी बाहर ला नहीं। description of articles received page 360 रे अछि से दीटा आइटम होची आइटम नंबर P1 नहीं पेज नंबर 360 27 ଆଉ 28 देखिलो तो 362
P and P1
received हला page 360 तारला serial number 27 and serial number 28. Result achi page number
362.
Page 362.
P1 and P. P and P1.
See, 27 and 28. No opinion, Asha. 362. P rehuchi human blood. No opinion about
P1 में no blood.
P1 में no blood. ये जो तारे human blood मिलिला P रे Pटा होची gene full pant of the accused. सेटा किसी tally करची disease माने को सहित क्यों DNA देखो फूड जान ले करनी conclusion ने किसी नहीं P विषय रे
Inclusion 5, 6, 7, 8, 15.
Regarding P Millard, only one point is there at point number 1 at page 358.
फिर अपने ये था जो ह्यूमन ओरिजिन मिला हमें तो नहीं ह्यूमन ओरिजिन मैचिंग नहीं डीएनए रिपोर्ट रहे
नो मैचिंग
does not indicate any matching with the blood of any disease. By the way, what is the particular question that has been put on this exhibit P, which was seized from appellant number 1. Appellant number 1, bro. accused statement रे पी विषय कौन क्वेश्चन पचराई जे तुमको गोटे ब्लू कलर रो जीन फुल पैंट जबत करा जाइथला जोटा कि केमिकल एग्जामिनेशन परे तादरे ह्यूमन ब्लड मिलला ए विषय तुम कौन कहू चाहो ये क्वेश्चन टा कोट पचराई accused statement
Question number 52, 53,
page
26.
Page 56.
Volume 1, page 26.
56 wrong. Question number
51, 52, and 53.
No.
51, 52, 56.
Page number with it 51.
26.
26, volume 1.
21.
26.
26 actually. कितना number serial?
Question number 53 million. That is particular.
Further transfer from the evidence of PW 15 that police seized blue color jean pant with a sticker, one cement color full shirt with bloodstain by exhibit 21. And though his evidence bloodstain shirt has been proved as MO1 and jean pant is MO2, man, tadire human blood bomb bhala. Eta say question kind. With reference to the C report finding that it contained human blood, but of course no group has been detected. So say question could Bajraj. Chemical C report mark kete number 50.
Exhibit 59.
Exhibit 59 reference है ताकि कौन question पकड़ाए
Page 56.
56
Question number 5.
56 से आरा accused टू पड़ेगा
नहीं
ठीक था दे रहेगा अच्छा हाँ कौन
Question number 5. The transfer from the previous report, exhibit 59 that all the exhibits, that is, exhibit A, B, C, D, F, G, H, J, K, K1, K2, L1, L2, M, M1, M2, and O, P, and Q, function document of human origin. What have you got to say, Mishra?
Accused statement, page number 56, question number 5. So, the evidence of the two witnesses, PW 15 and PW 41, that is there that that plant was seized. Both of them abstated, the IU as well as the independent witness, right? So that is all the evidence. Now, Mr. Mulia, just sum of the entire argument.
Can you see my line? The evidence of PW 5 and 6 were profitable. To examine the weapon of offenders in MO6. You can see the evidence. PW 5, 6, and 12.
कौन बाहर ला कोटर है?
मुझे पता नहीं PW 5 को जो नहीं लास्ट में एग्जाम में PW
नहीं से सीजर लिस्ट क्या कहते हैं?
19.
19 हाँ Exhibit 19 होची गोटे होची seizure of गामुछा से जो 19 ने आ गोटे होची कटारी जोटा भी मार्क है MO6 तारो witness होचंती PW 11 PW 35 और PW 41
Potter was examined by the doctor, my lord.
huh
Potter was examined by the doctor, my lord.
who is doctor
PW 5, 6 and 12, man.
PW 5
163
103
103 yes
कौन है कौन पूछंती से
It's a file like the notice of the my lord, PW 41, para 27, you can see.
कौन पहले PW 5 देखो ना तापर पुनी आधर जहाँ कहया था कही दियंतु पहले पर
41 डल बेटर 41 पहला 20 कही दो
PW
41 रो अगेन para 27 202
202
para 27 my lord, last
wait
MO6 after examination of the weapon of offense I received the same from Dr.
Paramita Pradhan, who last examined the weapon of offense, which was sealed and signed by the three doctors, such as people 5, 6, 7, 6 and 12, kept in my custody along with the signature on the proper paper covering MO6.
PW 41 waiting to portal page number 202 para 27 last 4 lines. After examination of the weapon of offense, I received the same from Dr.
Paramita Pradhan, who last examined, PW 5 man. PW 5. Doctor man. The page 104, the evidence.
104.
Ara man. 2 man. 2 5 9 6 9. This is my query report of me on murder exhibit 6 and this is my
प्रथम पढ़ना थी IAC produced कौन para 2 टा पढ़ना
on 13/11/2017 the IAC Kishanor case namely PN Lenka produced a cutlery before me for examination. I examined the weapon of offense and opined that the injury found on the dead body of the deceased Nabba ala Sekalabha is possible by the said weapon of offense. The injury found on the neck of the deceased can cause the death of a human being in ordinary course of nature. This is my query report opinion, murder exhibit 6. This is my signature on murder exhibit 6/1. Prosecution. The weapon of offense was produced before me without seal in open condition. At the time of post-mortem examination, the weapon of offense was not produced before me. I have not mentioned in my report as to who produced the weapon of offense before me. The weapon of offense was returned by me with proper seal. I do not remember if the weapon of offense was sealed with paper or means of brass seal. The specimen seal mark is not appeared on my report. I have not mentioned in my report that there is a blood stain on the weapon of offense. It is a fact that the exact age of injury cannot be ascertained.
No, in this was sent to for C examination.
Yes, ma'am.
What is the report?
Report is a match with my match with the DNA of the deceased man.
Who page?
Exhibit 59.
59.
Yes,
Page कहते cutlery of finding the exam.
Exhibit 59. For conclusion part. 59. Page 359. Page 359. Page 359. 5 minutes.
The DNA generated so and so cutlery is of human male origin, matching with the DNA profile of the deceased Nabo so and so. Okay.
I was stating, my lord. This lastly examined by this schedule 5 minutes. So there is no seal, without seal, man. Weapon of produced for me without seal. But see, can you see that schedule 6 minutes?
Just a minute. PW 5 says weapon was produced without seal.
No open condition. Para 3 of cross examination.
ଆପଣଙ୍କର appellant number 1 ର instance ରେ କଟୁରୀଟା ସିଜ୍ ହେଲା। ଯୋଉ କଟୁରୀରେ ରକ୍ତ ଦାଗ ଲାଗିଥିଲା ଯୋଉଟା କି DNA ଟେଷ୍ଟ ରେ ମ୍ୟାଚ୍ କରୁଛି ଡିସିଜ୍ଡ ନବ ଓରଫ ଏକଲବ୍ୟ ନାୟକର ରକ୍ତ ସହିତ। ଏଟା ଠିକ ତ? ହଁ।
I have not mentioned my report that there was a blood stain on the weapon of offense.
ଠିକ ଅଛି DNA ପ୍ରୋଫାଇଲ ତାଙ୍କର ସେ ଇଏ ସ୍ପେଶାଲ ଇଏ ନେଇକିରି ଦେଖିଥିବେ ତା ଦେହରୁ ମିଳିଲା ଦ୍ୟାଟ୍ସ ଏ ଡିଫରେଣ୍ଟ ମ୍ୟାଟର। ତେଣୁ ଏଇ ଓପନ ହଁ ଷ୍ଟିଲ୍ ଉପରେ କୁହନ୍ତୁ।
Page 105. 106, para 2. On 13/11/2017, subsequently the police produced the alleged weapon, that is chopper, for my query. On examination of said weapon, I answered the query affirmatively. This is my query, opinion marked as Exhibit 8. This is my signature on marked Exhibit 8 by 1.
Around how would have weapon?
I say weapon. Doctor exam.
factory କରୁଛି ସେଟା କଣ
chopper.
वही करतुली।
ठीक है जी।
There is only one weapon.
हाँ तो हाँ ତା ଦେହରୁ କଣ ଆପଣ କହୁଛନ୍ତି?
I cannot say who brought the alleged weapon of offense before me for my examination. I cannot say exact time of production and examination and handling over the weapon. I cannot say whether it was sealed or open. I do not remember whether I have given any seal after examination of alleged weapon. I have given the seal on the alleged weapon after examining of it.
Then both the witnesses are saying that it was not sealed.
Not sealed, man. P6 say I made seal, my lord. But last examined by the P5 was lastly examined, the weapon, my lord. He stated no seal.
And another witness is P12.
We could first examine the weapon offense. P12.
117.
There is 114. There is
117.
117. He stated weapon offense was produced by IO in a seal cover.
Goody.
Page 119, para 5, my lord. We first examine the weapon offense, my lord. Subsequently, the PW6 says he sealed the weapon offense, my lord. But PW5 says no seal. Therefore, there is no matter, my lord. The weapon was again sealed and it was sent to the FSL.
All the three of them are doctors.
Yes, sir.
Because they conducted postmortem examination over the dead body of different deceased persons, that is the reason why it was produced before each of them.
PW5 was lastly, my lord, examined the weapon offense. As per the evidence of PW41, my lord. He said, my lord, there is no seal. There is no matter, my lord. The weapon offense was again sealed and sent to the FSL. That means it is open.
But PW12 says that it was sealed.
12 first examined. This is a sealed condition. Sealed was open, they examined. Subsequently, there is no matter, my lord. The weapon was again sealed and sent to the.
Then your case is when it was produced before PW12, it was sealed. And thereafter not sealed.
Not sealed, man.
So therefore, PW6 and 5, when it was produced, it was unsealed.
PW5 last examined the weapon offense, man. He not stated, my lord, that seal was again it was sealed by the IO.
PW5 examined these weapons lastly as stated by PW41.
Yes, ma'am.
Who page re koichi
para
Para 27. 202. Case.
Para 27 is
202. I received the same from Dr. Pragya the present, who last examined the weapon of offense, which was sealed and signed by the three doctors as such P-Roll 5, 6, 12. But the P-Roll 5 not sealed.
तो फास्ट एग्जामिन कले पीडब्ल्यू कहते हैं
12.
First PW 12,
then
then
6.
The 6, then
PW 6, and then PW 5. Examine weapon. Forwarding report कौन देखो जी जितना
Followers we can see test 3, 4, 5 mile.
जितना जो weapon टा produce चला
3, 4, 5 mile. Test 3, 4, 5. Volume through.
Serial number करो.
Serial number 25 minutes. One broad-stem cautery having length 6.6 cm with of upper person 5.5 cm with middle person 4.0 cm with of the lower person 3.0 cm on the production by acting lovely focus द्वारा leading discourse but not sealed many.
एक forwarding report टा कैसे मार कीजिए?
57. 57. Page
343.
Serial number 25. Does not indicate that it was produced in court in sealed condition. Okay, Mr. Mulia, you sum up your argument.
In the case of adjournment circumstances,
Yeah.
motive is not proved by the
Just a minute.
In the case of melon, based on the circumstances, first circumstance was motive, second last century, then Milo, the DNA research report. Motive was not proved by the Milo, prosecution Milo. So it is judgment of Milo, appeals court Milo. Non-Dusing versus State of MP, 2022, 19 Supreme Court cases, 301.
Nandusing versus
Non-Dusing versus State of MP. Yes.
Reported in
Milo, 2022, 19 Supreme Court cases, 301.
which paragraph is relevant?
Para 9.
Para 9.
In case of based on circumstances, motive has been a very significant. It is not that if the motive alone becomes the physical link in case to be established by persuasion. In absence of the case of persuasion, must be described. But at the same time, complete absence of motive has a different complexion, such as absence described way in favor of actions.
This is regarding motive.
Any other citation on motive?
Another Shankar versus State of Maharashtra.
Motive रे कौन
Motive.
हाँ कौन Shankar
versus State of Maharashtra. 2022 23, 19 Supreme Court.
2023.
19 Supreme Court cases.
2023.
Yes. 2023. Pune Supreme Court.
AIR.
नहीं, Supreme cases.
ଆପଣ କହିଲେ ପରା 2022 ଟା ହଉଛି ଭଲ୍ୟୁମ 19
22 ରେ 19 23 ରେ ବି 19
23 ର 19
same 19 page 22
that
19
is not possible देखिए
no just see what is this 22 19 is see 23 19 is
23 और 19 टा
page number
madam 5553.
which paragraph
Paragraph number. In
10 yes noting 052
no para कोई नहीं भी नहीं para 10 में मोटी किसी में इसमें राजा 17 रे कंफ्यू माने कौन कौन सर्कमस्टांस अछि सीधे कहली ता द्वारा सर्कमस्टांस नंबर 3 टा होची मोटी और से सर्कमस्टांस नंबर 3 टा कोडी डिस्कस होई सेही ही थीवो मोटी
21. 21.
We come to the page number 565, our last sentence टा 565 paragraph 23 रो last line in the light in the light पढ़े सुन से पढ़े पूरा लास्ट
in the line.
हाँ तापर पढ़े वन करी
Night of the decision. Normal all the cases and Vivaji Chintava Patike also based on what he held in respect of impact of failure to establish the alleged mukti in a case based on circumstances it can only be held that the state failure has weakened the case of persecution, which access to have been given proper way by the court.
para 38 569
Anyway, the fact living from
thus in nutshell 38 that's in nutshell the effectiveness of the last in version emanating from
the nutshell of the correctness of the last in person emanating from the figure 8 in the petition down especially against the appellant hearing I notice that virtually oral testimony of figure 8 and figure 10 are variants about the last week. We become interested for the reasons mentioned here before. We have also found
we have also found that the prosecution has miserably failed to prove the alleged motive in such circumstances.
The decision made with the Mishra there, it cannot be said that the rest of the circumstances was called out by the court below on nearly point to the culpability of the appellant and the homicide death of Rahul only. Mishra. Even the recovery open offense.
In this case, the recovery was there. Last scene was there, but motive could not be proved. So therefore, court gave the benefit of doubt and acquitted.
Here,
This is-
in this particular case, the prosecution has advanced two motives. One is about the political hostility. The second one is to take that loan amount, which is robbery was committed, and for committing robbery, the crime was committed. So, but in support of such two motives, the evidence which are been given, according to you, that is not sufficient. So that is why the motive part has not been proved by way of clinching evidence. So that is your submission on motive. Any further submission on
The article was seen, man. That's seen.
no, on what you are citing decisions now? On what point you first say, so that we'll record it and take note of it.
In sir, for motive, these are two judgments. Okay.
Then next
Next,
point,
I think it's seized, my lord.
recovery.
To the FSL. Well, there is no matter so well whether it was kept in it was
Okay,
kept, my lord.
okay. Article seized. Not kept in sealed cover.
Not safe position.
Acha, not kept in safe position. Okay.
Safe custody.
Safe custody.
It was referred to the FSL.
Okay. What are the reasons?
On that day, last time I was.
No, seriously, Sainik Patricia, 1994. Sainik Patricia, December the 5th. Sainik Patricia was the state of Orissa. 1994 का हुआ उसका आरंभ होला 88 मसीहारे 88 अणानबे 90 91 92 93 94 so it is the volume 8 is this the volume 8
Volume 7.
89 yes.
Any other judgment you have?
Sainik Patricia कितना नंबर 200 pages. Also ये वॉल्यूम कितने 7 एशिया ये कितने 7 ठीक है नेक्स्ट
The DNA test reproduction and does it out. Does you kindly see the page 357 in respect to Miller.
No, they actually in this case the IO has the IO stated that he kept it in Malkhana?
No, man. No, Malkhana was not Malkhana.
Register is not.
Malkhana register not. IO has not even stated that it was kept in Malkhana.
Rather, in the contrary, he says that in my custody.
In my custody, right. And it was handed over to the next IO who has not been examined, right? Yeah, okay.
She also not stated whether she kept the article. No document was seized.
She said in my custody. We don't know where it is.
My custody, okay. Next. On what point you are?
Next, my lord. The DNA test report is also doubtful, my lord. Arsiv. In view of my lord, conclusion, Arsiv can see. Test 359.
DNA report on
para 6, my lord. The code is accused. For this, para 6, my lord.
You say DNA test is not trustworthy.
My lord. First, kindly see the conclusion part, my lord. Test 359.
Doubtful.
Para 6, man.
Para 6 of who?
Test 359. Volume, man. Volume 2.
For DNA test report finding on which item?
Item, my lord, in respect of Gamucha.
Gamucha not.
From the accused appellant or what?
Gamucha not acceptable. That is.
Gamucha is matched with my lord. Gamucha
Problem is Gamucha and Katuri.
Hmm?
Gamucha and Katuri, these are the two items which is linked
Gamucha is
with.
matched with the
Yes.
DNA of the Nava. This is Nava ecologonized. Para 6.
Para 6,
And DNA profile generated from exhibit mark O, purchased from the napkin of Akil Babuli, Prakash Bera, with dropout at DYS391 locus. Reference Journal of
সেটা যে দেখুଥିଲେ যে ফাইন্ডিং কিছু নাই
column table I page 353 column page 354
এটা 6টা DNA profile generated from ওটা হচ্ছে cut piece of napkin of accused so and so.
No opinion, it's a 62 আছে no opinion.
It matches is a human origin ওটা origin है ना and dropout হচ্ছে DY so and so and it matches with the cut piece of the shirt of Navo है ना तो ये जो dropout रे देखिया गले M1 বলছে পৌঁছন্তি M1 DY so না এটি কিছু ନାହିଁ তো ইয়ার হচ্ছে M1 র হচ্ছে কত 10 है ना तो এটি কইলে না ম্যাচ কলা কাছে 90 সাঙ্গরে 90 র DY so so drop out হচ্ছে 10 ইয়ার মধ্যে 10 ইলন ছিল যেটা ইয়ে বললা কিন্তু এই যে এই কট পিস র ন্যাপকিন এটি কিছু
কিছু নাই
sorry 11 number so how it matched with your dropout DYS391 ro dropout সঙ্গে কেমতি ম্যাচ করা লিখিছেন so এই যে ফাইন্ডিং টা সে দিয়েছি that is all
and there here also it says no opinion
এটা তো ব্লাড গ্রুপ নো opinion but DNA test র মধ্যে আসুচি যে তার কিছু আসে dropout does not matches not matches and I drop out though mentioned to be matching in serial number 6 page 359 but page 354 indicates table 4 in table IV that napkins dropout
is nil.
Dropout DYS391 is nil. That's all. Okay. তারপরে কোন লাগবে last scene କିଛି ଅଛି decision last scene decision ତାদের ଅଛି କହୁନାହାନ୍ତି କୋଉ paragraph ଟା ଆପଣ ଆମକୁ ଦିଟା ଡିସିସନ ଦେଇଛନ୍ତି ସେ ଦିଟା ଡିସିସନରେ କୋଉ ଡିସିସନରେ ଲାଷ୍ଟ ସିନ୍ ବିଷୟରେ ଡିସ୍କସନ
23
19 SCC 5 P two paragraph
last century led on
last item number
D man 10 last century led on
last item B
D man
D for Delhi
last century led on Adil D
এটা হচ্ছে paragraph number D রে কাই D circumstantial evidence, prerequisites condition, describe 5 golden principles, so and so.
First page, missing.
First page.
আচ্ছা এটা মানে এটা হেডিং এ আছে last in relied upon so and so
Link in the chain of convention, the evidence related to time at which the issue last stage with the accused has to be proved conclusively. As when it was a presumable with the kind of dead body, the warden to express innocence would be that of accused.
This is appreciation of the evidence of that case. Where is the law? PW8 and PW10 was appreciated, that's all. And they say that is not true.
Another decision of my appeals court manner. Seal was not produced before the appeal.
just a minute. Last in see dita evidence thila PW8 or PW10 no ତାକୁ appreciate କଲା ପରେ କହିବେ ଯେ ମାନେ that is not acceptable but law ର ଇଏ କିଛି
nothing is
discussing
issued, isn't it?
Issued.
Now this one, seal was not produced before the forensic.
Konda?
Seal was not produced before the forensic laboratory for comparison.
The other judgment.
Last 6 lines. To further find that no sample of seal was sent along with the sample to the Excel laboratory for the purpose of comparing with the seal appearing on the sample bottles, that there is no evidence to prove. That is that the seal found were in fact the same seal was put on the sample bottle immediately after the seizure of comparison. And these loopholes in the prosecution press and led the High Court to act with the respect.
So here, whatever the last seen evidence has been adduced, that does not relate to either the deceased Tarini or Tarini Naik or Ekalabya Naik. That only relates to that Biranj, right?
W
37.
37.
And to that effect, evidence of PW 37 is relevant. Because evidence we have already read and discussed also. So,
It must take the name of the.
because the main thing is that what you advance the argument that he saw the man for the first time, these two appellants, and then he identified them in court
after 6 years.
After 6 years, and no test identification parade was conducted, and apart from that, he made a belated disclosure also. That was perhaps your submission. The date of
after 1 month.
After
22 days.
Because occurrence took place on 9/10/2017. यार 161 टा record ହେଇଛି
161 କିଛି କହିବି ନା କାରଣ
8 161 record ହେଇଛି 17/11/2017 161 का ना नहीं ଏବଂ कोर्ट एग्जामिनेशन ହେଇଛି 8/12/2023 अर्थात 6 वर्ष ପରେ.
Insofar as the other two homicidal death is concerned, prosecution has not attempted to bring any evidence except that DNA test link. There is nothing. No witnesses are produced, nothing is there. Is not that correct? Yes. If DNA test goes, insofar as those two murder is concerned, that can't be linked with these evidence at all.
We'll hear you. Let him
just come
because he's summing the argument. He is finished. Yes. Any other submission?
The chain of link was completely missing.
The chain of circumstance is not complete, and that is your submission. So that's all. Because we will hear you on, of course, on this death
sentence.
We are hearing it on now merit. So we'll hear you afterwards. After we hear Mr. Okay, before going to Mr. Tripathi, we are to give an opportunity of hearing to Mr. Panda. Mr. Panda, you are engaged as the amicus curiae. So,
want to add anything?
Anything you want to add to Mr. Mulia's submission?
Apart from that, Your Lordship, in the case rests on circumstantial evidence, and the points for consideration by the London trial court is, Lordship, kindly have a glance to judgment and page number 219. Page 219. The points for consideration.
Who volume Rachi?
Volume 2. Page 219.
Para 4.
Para 4.
Yes.
May I please, Your Lordship?
219.
May I please the points, Your Lordship? Whether on 9/10/2017 at 3 different places, these two accused persons had committed the murder of Biranchi Naik, his wife Paran Naik, and their son Nava Naik, alias Ekalabda Naik, in furtherance of their common intention. Now, prior to that, Your Lordship, kindly have a glance to the charge at 302, 449, 366, 364, 394, 201, 34 IPC, Revenue Section 25 and 27 of Arms Act. Thereafter, Lordship, kindly see. Point number 2. Whether on the alleged date and time the accused persons had trespassed into the house of Biranchi Naik with the intention to get the loan amount which Biranchi received from Ma Maheshwari SSG Group. Whether the accused persons...
That is motive.
Whether the accused persons committed robbery in the house of Biranchi Naik to take cash and household articles in furtherance of their common intention. Whether on alleged date and time the accused persons had abducted,
kidnapped Biranchi Naik and its son Ekalabya Nabha alias Ekalabya Naik with intention to commit murder in furtherance of their common intention. Whether on the alleged date and time the accused persons had destroyed the prosecution evidence in order to escape from criminal liability in furtherance of their common intention. Whether on the alleged date and time the accused persons has illegally possessing one sharp-edged cutlery and had used the said weapon for the commission of murder of 3 deceased persons. Then also kindly turn to page 236 regarding the principle of circumstantial evidence. Leave it that principle we know that. Then also come to page 238, coming to the part of house trespass and commission of robbery. You are also in 236, the motive of the accused to grab huge loan amount from Biranchi. This is the only motive, to grab the loan amount. And the offences alleged are 449 and 394. Coming to the part of house trespass and commission of robbery. It is found from the evidence of IO that on the relevant day of
this page number 236, he has noted down all the circumstances which are available on record against the two appellants or the condemned prisoners. So the first one is motive of the accused to grab huge loan amount from Biranchi. Number 2, preparation to call Biranchi for melody.
Purchase of liquor, water.
Number 3, purchase of liquor, water pouch and mixture for commission of offence. No explanation by accused persons for last seen with deceased Biranchi on 9/10/2017. Taking Biranchi to Kala Patlani to see melody as the melody of Thakur God was not good. Then dead body of Biranchi was found near Pokonda Bridge, which comes on the way to grocery shop to Kalapatani. Bloodstain found on the Katari is of human origin and of Nabo and Ekalabya Naik. Bloodstain on the codpiece of shirt of so-and-so matches with so-and-so of napkin of one. Bloodstain found on the codpiece of banyan of so-and-so matches with the full pant of so-and-so. So these are the 9 circumstances that have been chalked out by the learned trial court, and then he started discussing on each of the circumstances, right?
On the foundation of the circumstance is the motive. Motive is to grab the huge amount of the loan. Accordingly, the offences are 449, the house trespass, and 394. And the finding on
then
that.
Come to 238. You are reading.
237. Now coming to house trespass and commission of robbery.
Where from this evidence has come? Para 7?
Para 7. It is found from the evidence of IO that on the relevant day of occurrence, accused persons had come to the house of Biranchi, where his wife Tarani Naik, his son Nabo alias Ekalabya Naik were present. The accused persons asked money from Tarani for treatment of Biranchi Naik, pertaining his accident. At the time when Tarani Naik saw the bloodstained cloth of the accused person, she cleverly trying to move outside, and at that time, the accused persons, without giving any time, cut her throat, but with that cutting throat, Tarani Naik ran to outside and fell inside the horror.
Where from this story is
evidence of the IOU confession.
Confession. There is nothing.
However, in this regard, to 239 towards the middle of the para. However, in this regard, those stories of house trespass available from the IO of evidence, at the same time, no such independent witness had given their statement in this regard to establish that the accused persons have trespassed into the house of Biranchi to take the loan amount from his house and thereby committed murder of Tarani and her son
noble is equivalent. So in view of the prosecution failed to establish the fact of house trespass and commission of robbery by the accused person in the house of Birantinite.
If that part is not believed, then apart from motive fails, insofar as the two other models are concerned, that is also taken out. A robbery goes, then that part of the story is completely goes.
So the foundation of the case is motive fails. On the discussion of the law and trial court, motive fails. The house trespass and commission of robbery to grab the huge amount. The commission of robbery, the accused person in the house of Biran.
Coming to the part of kidnapping. Coming to the part of kidnapping and next 8.
Now coming to the part of kidnapping and abduction. In this case, there is no direct evidence available except the last in theory, wherefrom it is found that the accused Biranchi was moving through a motorcycle of the accused person to see Melody.
But from the last in theory, you can't infer the kidnapping.
Last in theory only attributed to Biranchi.
Biranchi, not that Ekalapya.
No.
Yes. The story is both Ekalapya and both.
So moving with the consent to see the melody by the accused persons cannot be considered that he has been taken forcefully and according to the fact of abduction could not be proved. So far as the dead body of Ekalapya found inside the jungle after taking from his house clearly establishes the fact of kidnapping. Who has stated that? According to the prosecution has successfully proved the kidnapping of Nabba alias Ekalapya from circumstantial evidence.
Which evidence? This inference is drawn.
Evidence of
kidnapping of Ekalapya. Who has said?
Evidence asking clearly.
Mr. Tripathi?
No further evidence.
Evidence could diala.
How the trial court is giving the
okay. Now we come to the
disappearance of evidence.
Only IO evidence.
आयोग तो सब कही दी था अन्य मानू का एग्जामिन कले आयोग आसी कही था मु यहाँ सब रेकॉर्ड कली ए माने या कही था जे माने या कही जंदी बस तो ठीक है जनाब नेक्स्ट.
Now coming to the part of disappearance of evidence, it is found from the circumstantial evidence that after commission of murder, they have dragged the dead body of Biranchi from Pokonda Bridge and then threw it on Pokonda Bridge in order to destroy the material prosecution evidence. Similarly, from the circumstantial evidence, it is also established that to destroy the prosecution evidence, they have thrown the dead body of an Abale Ekalapya inside the Gotmulia jungle after cutting his throat. It is also established from the confessional statement of the accused person, seconded under Section 27 of Evidence Act, that after commission of crime, they took steps to hide the incriminating weapons, that is, cutlery and their bloodstained cloth, in order to destroy the prosecution evidence. So, considering the above circumstantial evidence, it is clear that the accused persons have taken steps for disappearance of prosecution evidence in order to protect themselves in the criminal liability. So, this comes from the statement taken under Section 27.
Next,
regarding 25 and 27 of Arms Act. May I place that?
But is disbelieved.
Disbelieved.
Conclusion पढ़ेगा.
In view of the above discussion, the prosecution has proved the case under Section 302/364/201 34 IPC against the accused persons beyond a reasonable doubt, and accordingly, accused persons are found guilty of the above offence, and they are found not guilty under Section 363, 394, 34 IPC, and Section 25, 27 of Arms Act. But there is
what further submission you want to make?
Well, my submission is, since the foundation of the case is motive and motive has not been proved, so there is fail in chain of circumstances.
No, because it is a case based on circumstantial evidence, and prosecution has failed to, though they have advanced that these are the motives and they have failed to establish the motive part, it has got some significance, which would not have been there if it is a case would have been based on direct evidence, because in a direct evidence, even the prosecution does not prove any motive, it is irrelevant, because it is to be seen whether the eyewitness's account is to be believed or not. So that is the basic difference of the motive or importance of motive in a case based on circumstantial evidence and not in a case which is based on direct evidence. Any further submission?
What?
Let's say we proceed to hear on sentence.
Please take your seat, then you will argue. Yes, argue.
My lord, I will file a written note of submission.
Where is that?
I will file it.
No, but we'll give the chance to both of you. We see on merits, we are listening today, and once that is over, we'll hear both of you on the death sentence, and you may cite also the decisions. Then we'll give you the chance to file your written note of argument. So we are now on merit, and on merit, the learned counsel for the condemned prisoners in that death reference as well as the appellant, Mr. Molia, they have advanced the argument. So how do you say that the findings of the London trial court on the last scene, the motive part, the DNA test finding, and this seizure list, etc., are acceptable, and whether that form a complete chain that the appellants are the author of the crime in respect of all the three deceased. There are sufficient evidence, because admittedly, even if we take into account the last scene, that is only with respect to one accused, and that is deceased Biranji, which is deposed to by 37. So when our query to you is that when a witness like PW37 is not aware about the names of the two accused persons who had come to his grocery shop on that particular day for a few minutes to purchase the pouch and the water after taking liquor from the liquor shop, and why you did not conduct any test identification parade, and why their identification for the first time in court, why the evidence of identification of PW37 to these two appellants in court after 6 years will be believed. That is our first query to you. You are to make your submission on this aspect itself. We are considering now the last scene, your reply to this last scene.
Well, here the submission of front counsel for the appellant is that in 161 statement, PW37, that is Girish Kumar Sahoo, he never stated the name of any person. And in the deposition, he says at page 174 that he at about 9 p.m. to 9:30 p.m. these two accused persons along with another, namely Biranji, had come to the counter. Whether he has stated the names of the accused persons or other persons in the 161 statement or not, that is not confronted to this witness at the time of cross-examination. Let's even take note of that.
We have noted down.
Yes, ma'am. Here, there may be possibility that these shopkeeper may be knowing these persons prior to that.
No, how can you say, please come to the evidence? Your evidence in that that PW37, come to the evidence PW37. Page 175 is the cross-examination.
He says he had no prior acquaintance.
Right.
With the other
I was knowing only Prakash Behera alias Babuli prior to the case, as he had a furniture shop at Thakurgad Market. I had no prior acquaintance with the other accused Nanda Kishore Sethi. Right?
The examination chief in the paragraph 1, just see.
He said, it's true.
There also he says that he knows one accused and the deceased.
And so far as the deceased is concerned, paragraph number 4 also he said that I had no prior acquaintance with deceased Biranchi.
But the chief he says that he knows.
And
chief he says that I know Biranchi, but in the cross he says
ତେଣୁ
no.
ଦୁଇଟା appellant ଙ୍କ ଭିତରୁ ଯଦି ସିଏ ତାର appellant ନନ୍ଦକିଶୋର ସେଠୀ ସହିତ prior acquaintance ନଥିଲା ଏବଂ ଘଟଣା ଦିନ ସେ 10 ରୁ 12 ମିନିଟ ପର୍ଯ୍ୟନ୍ତ ସେମାନେ ତା ସପ୍ କୁ ଆସିଥିଲେ ତାର ଗ୍ରୋସରୀ ସପ୍ କୁ ଯୋଉଠୁ ସେମାନେ ଗୋଟେ ୱାଟର ପାଉଚ୍ ନେଇଥିଲେ ଆଉ ୟୁଜ୍ ଆଣ୍ଡ ଥ୍ରୋ ଗ୍ଲାସ୍ 3ଟା ନେଇଥିଲେ ଆଉ ମିକ୍ସଚର ନେଇଥିଲେ ଏଇଭଳିଆ ଯଦି ଏଭିଡେନ୍ସ ସିଏ ଦଉଛି ତାର କିଛି ଦିନ ପରେ ଯଦି ନନ୍ଦକିଶୋର ସେଠୀ ଆରେଷ୍ଟ ହଉଛି then why at least in respect of Nandakishore Sethi no test identification parade was conducted because he is identifying the accused persons in court after 6 years. So,
and more particularly in the 161 statement, the same witness has not taken the name of anyone. Yes. So, TI period was inevident. It should have been done. That is about last scene. Next.
Then next is regarding safekeeping of the seized articles. And it is the case of the appellant when the safe custody of all these seized articles is doubtful, then it leads to the conclusion that the chemical examination is also doubtful.
Kept in his own custody and gave it to the other IO.
Yes, ma'am.
That after 20 days,
yes,
that IO kept in her custody. Again, after 20 days, he sends it to the chemical examination.
Here, let's come to the evidence seizure list under exhibit 19.
19, yes.
That is the most vital seized article, that is Kottari and Commission. 19.
କେତେ ନମ୍ବର ପେଜ ଅଛି କୋଉ ପେପର ବୁକ୍ ର କେତେ ନମ୍ବର ପେଜ
Volume 2, Miller.
Volume 2
Page 291.
291, yes.
Please.
Yes. In the column number 4, Miller, it was seized on 12/10/2017 at 9:30 a.m. From the cultivable land of Boiragi Naik of village Pokonda. Now let's come to serial number 8. Action taken recommended for keeping valuable property. It is written, it is kept at PS
Malkhana.
PS Malkhana. But in respect to some other seizure list, let's kindly turn to exhibit 21.
21 also Malkhana.
Yes, ma'am. It was kept in the Malkhana. Exhibit 21 towards the bottom.
Yes.
Set serial number 8.
Exhibit 22 also Malkhana.
Yes, ma'am. I'm coming to that. Let's look at. The same serial number last towards the bottom. Malkhana. Now, here taking a pause for a moment. May I
Yes.
Attention to the deposition of PW 41, that is the IO. At page 199, that is volume 1.
Just a minute.
In 200, he says that then I kept in my custody. The articles.
कोटा कितना नंबर
199 Miller. Paragraph 23. First 2 lines.
I kept in my personal custody
After making the
with
seizure.
proper packing and sealing.
Okay.
Very specifically says personal custody.
Yes.
And in the end of this paragraph also in 200, he says that I came back to the PS along with the accused person and seized the article and then kept it in my custody.
Now
This
the-
evidence is contrary to that seizure list where it says kept in Malkhana.
My lord, when it is kept in the Malkhana as per the provisions of police manual. Now he says, I kept it in my custody, and in other paragraph he says, I kept it in my personal custody. Here, it is to be linked, my lord. My custody means the custody provided under the police manual, that is Malkhana. Apparently, this part of evidence is not brought before the trial court.
But what is the corroborating evidence? Suppose you say that what the IO means, that his statement that I kept it in my custody, coupled with what has been written in the seizure list that in police Malkhana, it presupposes that after the seizure of the article, it was kept in PS Malkhana. That is your submission. But the corroborating evidence would have been that at least since he has not specifically stated that I kept in PS Malkhana, the corroborating evidence that it should have that Malkhana register copy should have been produced, which would have strengthened the evidence of the IO that yes, it was kept on this particular date and it was taken away on this particular day. କାହିଁକି ଦେଖନ୍ତୁ ଆପଣଙ୍କର ଯୋଉ weapon of offense ଟା ଆଣିକିନି ତାକୁ ରଖିଦେଲା PS ମାଲଖାନାରେ ଯଦି ଆପଣଙ୍କର ସିଜର ଲିଷ୍ଟ କୁ ବିଲିଭ ହୁଏ ତିନିଟା ଡାକ୍ତରଙ୍କ ପାଖରେ ତିନିଟା ଡେଟ୍ ରେ ପ୍ରଡ୍ୟୁସ ହେଇଛି what does it implies that ସେ ତିନିଟା ଡେଟ୍ ରେ ସେ ମାଲଖାନାରୁ ବାହାର କରିଛି ସେ ଆଇଟମ ପୋଲିସ ବାହାର କରିଛି ଜଣଙ୍କ ପାଖରେ ନେଇ ପ୍ରଡ୍ୟୁସ କରିଛି ପୁଣି ଆଣିକିନି ତାକୁ ରଖିଥିବ ମାଲଖାନାରେ ପୁଣି ତାକୁ ଆଉ ଗୋଟେ ଡାକ୍ତର ପାଖକୁ ଆଉ ଗୋଟେ ଦିନରେ ନେଇଛି ତିନିଟା ଡେଟ୍ ରେ ସେପାରେଟ ଡେଟ୍ ରେ ତିନି ଜଣ ଡାକ୍ତର ଯିଏକି ତିନିଟା ପୋଷ୍ଟମର୍ଟମ କରିଛନ୍ତି ତାଙ୍କ ପାଖରେ ଏଇ ୱେପନ ଟା ପ୍ରଡ୍ୟୁସ ହେଇଛି ତ ଯଦି ଆପଣ ମାଲଖାନା ରେଜିଷ୍ଟର ଏଣ୍ଟ୍ରି ଥାନ୍ତା ତାହେଲେ ମାଲଖାନା ରେଜିଷ୍ଟର ଗୋଟେ କଲମ ରହୁଛି ଯେ କେବେ ଆପଣ ମାଲଖାନାରୁ ସେଟା ବାହାର କଲେ ହେଲା ଏଇ ଦିନ ଆପଣ ରଖିଲେ ଏଇ ଦିନ ବାହାର କଲେ ତାପରେ ପୁଣି ଆଣିଥାନ୍ତେ ସେ ଇଏକୁ ଆଉ ଗୋଟେ ଡେଟ୍ ରେ ଏଣ୍ଟ୍ରି ହେଇଥାନ୍ତା ବୁଝିପାରୁଛନ୍ତି ନା ତ ସେଇ ଗୋଟେ ଏଣ୍ଟ୍ରିରେ କାମ ହେଇନଥାନ୍ତା ଏଇଟା ପ୍ରତ୍ୟେକ ଦିନ ପାଇଁ ସିରିଆଲ ନମ୍ବର ପଡିଥାଏ ମାଲଖାନା ରେଜିଷ୍ଟରରେ ଡେଟ୍ ସିରିଆଲ ନମ୍ବର when it was kept by whom when it was taken out and for what purpose ସେଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ଯଦି ଆପଣ ଲିଙ୍କ କରିଥାନ୍ତେ ଯେ ଆଜ୍ଞା ଅମକ ଦିନ ରଖିଲେ ଏଇଟା ହଉଛି ତାର ଏଣ୍ଟ୍ରି ନମ୍ବର ସୋ ଏଇ ଦିନ ଏଇଟା ବାହାର କଲେ it was produced before the first doctor then it was kept again and again it was brought out so finally it was taken away to be produced before the court for sending it to the chemical examiner. ताले समुदाय रखिबा परे आपण चारिटा डेट रे आपण आईओ एविडेंस को जदि एक्सेप्ट करा जाए चारिटा डेट रे से मालखाना ये बाहरी अदरवाइज जदि मालखाना रे थिला सेफ कस्टडी रे ताले चारिटा डेट रे ये बाहरी तीनटा डेट रे बाहरी तीनटा डाक्तर को पाखे प्रोड्यूस करिया को आउ गोटे डेट रे बाहरी नहीं कि कोर्ट रे प्रोड्यूस करिया को मालखाना. So it is a very vital piece of evidence. से जो मालखाना रजिस्टर टा यही circumstance रे कारण से जो
You can link with the crime with that evidence only.
कारण आपण गोटे कहउचंदी से जो रक्त लागिची से क्राइम ये रे वेपन ऑफ ऑफेंस रे that relates to the blood group or DNA profile रे मैच करूची on जने डिसीज सहित right.
See, there is a difference between custody and control. You are not only in the custody, as well as you are in control of that. If you put it in the Malkhana, the control goes to the Malkhana authority, whoever is the Malkhana in charge. He gives you on requisition and you have to deposit it back. So you lose the control. The chance of manipulation is less. That's the idea. And but here you say that in my personal custody I kept it. Then whenever you wanted, you took it. Whenever you wanted, you throw it in.
Sometimes the IIC in police manual it is there also. The IIC can be also the Malkhana in charge. That is there. But all those things are to be recorded there. That I kept the Malkhana and Malkhana entry number. But you yourself said that in the case diary there is no mention at all.
That I returned to the police station with all the articles.
That's all.
That's all.
He has not mentioned that he kept in the Malkhana. So if he has not mentioned in the case diary, if he is mentioning in the seizure list, is it sufficient to show that it was kept in safe custody, particularly when it has been taken out for 4 times? Repeatedly. So how far the importance can be given to the finding of the bloodstain which matches with the theology kete number kotari ha jone deceased ro nabo soito seta ye kara jachi.
Yes,
maybe going out of the record, my lord. That's on that day I was bringing this to your lordship's attention, my lord. I called for the Malkhana register, original register. I verified it. Everything is written there. When it was put in the Malkhana, on what day it was brought, and when again it was put to the Malkhana, everything is noted in the register in a transparent manner. But
that's not done.
Because once we
my lord, apart from that, my lord, these first IO and second IO both are signed in that Malkhana register.
It is the laches of the prosecution.
Yes.
And at this stage, appellate stage, because if we say, because it's a new type of evidence, it is coming. Malkhana कारण आयो निजे कहिनी केस डायरी मेंशन हेनी आपण गोटे मालखाना रजिस्टर को आनिचंदी वर्तमान प्रोड्यूस करिवे आपण ए तो हाउ फार दैट वुड बी कारण आपण जदि मालखाना से एविडेंस नहीं थांते तार कॉपी देई थांते यू वुड हैव गॉट द चांस आल्सो टू क्रॉस एग्जामिन द विटनेस. सो वर्तमान आपण जदि ताकू प्रमाण करिवे तो डेफिनेटली दैट विटनेस वुड कम हु हैज केप्ट इट. And again, the matter, they would be given the chance in the appellate stage to cross-examine that witness. Then the question would be that this is all is likely to prejudice them, serious prejudice. These are all lacunas pointed out during course of argument. And you are trying, if you try, allow you to patch up that lacuna, then that would be end of the criminal justice system would fail. आपनकर जहा पॉइंट आउट करिवे डिफेंस काउंसिल ड्यूरिंग आर्गुमेंट आपन कहबे आया हां ठीक अछि सेटा गोटे भूल हे जाइतला मते गोटे साक्षी दियनु मोडे एग्जामिन करिवि तणु
all about the record, Miller. It's all about the record. Documentary evidence.
So I remember that I was arguing a matter that the occurrence took place in the night time, and the distance I have brought in the cross examination that it is about 250 feet or something like that. So the question of identification of that person from a distance of 250 feet, I raised the contention in the appellate stage, how far it is acceptable. And the additional government advocate, on the very next day, he filed a petition like what you are telling, that I want to produce a seizure list which shows that at that spot there was a light post. So, and that evidence should be, the IO should be examined. All fabricated thing he brought out. I filed the objection that this is not there in the evidence, neither any IO stated, nor you have brought out from the that there was any light post. I am arguing in the appellate stage that what is the evidence of identification from a distance of 250 feet, and that was day of Amavasya. And you are telling that there was a light post and the you were proving a seizure list. That petition was rejected by the filed by the additional government. So you see, these are the things it cannot be allowed. Otherwise, it would create.
Subject to lots of consideration, Millard. That light post, everything, Millard, it's a different context. Here, Millard, the document. Person may say lie, person may lie, but the documents do not, Millard.
No, person may say lie, but if you are the official document, that can be also created.
That can be created.
That can be created if you are producing it after so many years, and the document is in your possession, and if you will not seize it at that point of time, nowhere mentioned that what is the Malkhana entry number, and
who stopped the IO to say that I kept it in Malkhana? Who stopped? If he had kept it, he should have told. See, he should have been the deposition. He should have said that instead of saying that I kept it in my personal custody, he could have said that I put it in the Malkhana. That would have been suffice. That would have been a corroborative evidence to that seizure list.
When Millard, this exhibit 19, 20, 21 and 22.
That's the only strength.
For your Lordship's consideration, Millard.
That's all.
It says just put in the Malkhana.
You see, show that police manual. Come to that Malkhana chapter. What is this book? Kete number page? Taro yeta rules or kete number achi? Malkhana statement achi. Sahe? 1940. Just see that. Please read it out.
You have the copy? Give a copy to
me. Give me a copy. Police manual. You see, these things I have discussed in some judgments which we have given in that NDPS Act matters. So, Orissa police rules.
119.
19.
Read it.
Rule 119.
The register of property in possession of the police. All identifiable property stolen, whether recovered if not, and all articles of which the police take charge shall be entered in detail with a description of the identified marks on each articles in a register to be kept in the PM for number 18 in duplicate, and a receipt shall be obtained whenever any article of property of which the police take charge is made over to the owner, sold, spent to the court, or disposed of in any other way. These receipts shall be numbered serially and filed, and the number of the receipt shall be metered in column number 7. On identifiable property, when the rule requires its entry, that is when the police take charge of it, shall be entered in bulk, the number of articles, value, and general description being merely noted. Gold and silver materials and other valuable materials seized by police will be tested by a goldsmith at the time of seizure by the police officers concerned, and the certificate obtained from him in this regard The articles will also be tested by a goldsmith at the time of their acceptance by the officer in charge of the court, Malkhana, and discrepancy, if any, should be immediately brought to the notice of the SP of the district by the court concerned. In order to ensure efficient working of the above procedure, the district SP and the CJM of the district, in consultation with each other, shall prepare a panel of goldsmiths to attend the work of such police station and court Malkhana. The rate of remuneration of the goldsmith for each police station would be fixed by superintendent of police of the district, taking into consideration of the tenure and volume of the work. The bills of the goldsmith duly certified by the OIC of the PS for attending to work during investigation of case shall be paid from investigation charges sanctioned for the district establishment and left at the disposal of the superintendent of police. Then Malkhana statement. The original will serve as a Malkhana statement and be forwarded monthly by the officer in charge to the court officer, who will deal with it as laid down PM Rule 307 and 324 to 328. Where there is no court officer, this statement will be forwarded to the magisterial clerk, who will deal with it as laid down in PM Rule 327 and 328. On the first of each month, all items of property received in previous months, which are still in hand, shall be brought forward. These serial numbers of each item only shall be copied, and if disposed of, column number 7 shall be filled up. If still undisposed of, column number 8 shall be filled up. All orders regarding disposal of property other than those passed in final memoranda shall be filed in original and number. The number of each order shall be quoted in column number 7 of the register for rules regarding the register of arms deposited at police station and manner of control and verification of arms, Rule 25.
Have you got the copy of that form? Malkhana registered form.
18.
18.
Form 18.
Form number 18. ଆପଣଙ୍କ ପାଖରେ ଅଛି ପରା ଗୋଟେ କପି କଣ ଆଣିଥିଲେ ଦେଖିଲ?
କୋଉ ଫର୍ମ? Form 18.
ସେଇ ଯୋଉ ମାଲଖାନା ସେ ଯୋଉ କହୁନାହାନ୍ତି ଯୋଉଟା
ରେଜିଷ୍ଟର
ସେଇ ମାଲଖାନା ରେଜିଷ୍ଟର ଅଛି କଣ କଣ ଏଠି ଆଣ Rules 119, 120 to 37. तार फास्ट कॉलम टा होची
description of part.
हां एटा को केस नंबर बोले प्रथम टा तापर होची description including weight and where necessary. तापर होची value. तापर होची where, when, by whom, and the circumstances under which it was found, column number 5. Then 6 is date of receipt at the police station. 7 is date and manner of disposal of number of received, so and so. जो दिन थानारू नेले पुणी आनिले एटा होची सेया. तापर लास्ट होची रिमार्क्स कॉलम. तो आपनकर एई केस रो एटा कोटा कहउछंती?
Seized by Inspector so from the spot house of Viranji Naik. There must be another register, dispatch and receipt.
नहीं ये ना ये जो कॉलम रे लिखा वो दिन तुम बाहर करो ये जो कॉलम नंबर 7
column against the column no entry. There is no entry.
Column number 7 रे किछि एंट्री नाही देखछन तो
केबे बाहरला केबे गला
just show him. रखिला परे जो दिन रखिबो डेट देबे जो दिन जो पर्पस पई मारिबो जोठी कि नेबे सेटा होची कॉलम नंबर 7 तादे लेखाई जो पटा के पड़ी कोन लेखाई
ये लिखाई छी डेट एंड मैनर ऑफ डिस्पोजल नंबर ऑफ रिसीव्ड इन द फाइल ऑफ रिसीव्ड
जो दिन मार्कनारू बाहर करिवे सेटा एंट्री से दिन हबो तापरे कोर्ट की नेकी जाउछंती डिस माने कोर्ट को हम नेकी गली प्रोड्यूस करिवो so
that perhaps the reason the prosecutor might have said don't execute, nothing is there.
तो आपण जो वर्तमान एडवांस करूछंती यदि एई डॉक्यूमेंट को आपण प्रमाण करिवे बुझिले आपण आनी रखी देले रखिबा डेट ता अछि तापर आपण ओरल एविडेंस दउछंती तीन थरो ताकू बाहर करछंती तीनटा डाक्टरन को पाखर प्रोड्यूस करिया एठी थाना ए जो थाना मालखाना रजिस्टर रे नाही ता माने जो आपण कहउछंती डॉक्टर को पाखरे प्रोड्यूस कले तांकर ओपिनियन नेले ए डॉक्यूमेंट ताकू फॉल्सिफाई करियो इट विल गो अगेंस्ट यू कारण जेते थरो बाहर करिवे डेट एंट्री करिवे पुणी आनी रखिले से आउ गोटे सीरियल नंबर हबो आउ गोटे डेट हबो कारण से डेट रखी दिबे आउ गोटे डेट रे प्रत्येक डेट सरी गला पर गोटे गार पड़ियो हैला 12 तारीख रे एतिक आइटम रहिला मालखाना रे सरला गार पड़ला आपण ताकू 11 तारीख रे रखिले 15 तारीख रे ताकू बाहर करछंती प्रथम डॉक्टर पांग नबा पई तो 15 तारीख एंट्री हबो सेठू बाहरला से आइटम टा बाहरला सबु नुहे ए आइटम टा बाहरला हैला ताकू आनी किनी 15 तारीख दिन डॉक्टर बांगू देखैले आनी ताकू 16 तारीख दिन रखिले पुणी गोटे एंट्री हबो 16 तारीख दिन रहला पुणी आ गोटे तीनटा डाक्तर पाखु तेणु आपनकर टोटल 4टा एंट्री हेई थांदा तेणु
डेट ऑफ रिसीव्ड एट पुलिस स्टेशन
हां पुलिस डेट ऑफ पुलिस स्टेशन रे गोटे एंट्री रोज को दिन द पुलिस स्टेशन रे रिसीव कले
सेटा भी खाली अछि
तेणु डेट ऑफ पुलिस स्टेशन रिसीव नाही केते थरो बाहर करचंती नाही एटा को वर्तन आनी किनी दउचंती एटा आपन अगेंस्ट जियो
So is written in second and third page, but it's not legible.
कोडा
Second and third page रे तो सेगुडा कॉल्स legible code.
ने आपनकर पर से जो वी आर कंसर्न विथ दैट से जो कोनता ना
Column number 7.
वेपन ऑफ ऑफेंस ता मेनली और कोन
and banyan
बनियन गुडा
banyan and katuri
आपण जो येटा कहले वेपन ऑफ ऑफेंस ता जो एती थरो बाहर करछंती या देर नाही ना आपण से कॉलम ब्लैंक रहउची पुलिस स्टेशन ने केबे रिसीव कले से कॉलम ब्लैंक ताको आपण जो ये नै चंदी से कॉलम ब्लैंक तो केमती आपण कहउचंती एटा को मार्क करिया को maybe that may be the reason, as my esteemed brother has pointed out, that he might have verified the public prosecutor conducting the case. जे जानछि जदि एटा नि मु प्रमाण करिवे सब क्वेश्चन आ ऊपर पचारिवे हां कारण ए जिंस जदि तांको नजरे थांता डिफेंस सी तो मगई दी था कहता या से मगांदु सेटा एटा ता फेवर रे जाउछि ना
that makes your case worst if you bring this document. Yes, anything else?
How come कहिबे ना सुनिबा डेथ डेथ ऊपर
So far the motive part is concerned.
Yes.
There is nothing to improve on.
गोटे कॉपी हमें रखु दिलो फाइल जस्ट कर तो रखु हां कोन
Motive part in
You can't improve.
motive part there is nothing to improve.
Motive evidence is very weak.
Very weak.
आपनकर मोटिव पाई जो जिंसडा ही हैज पॉइंटेड आउट मिस्टर पंडा आपन कहिले जे घर भितर पशिकिनी जो कौन चोरी करिया पाई ये कले सब जिनस जो कले से चार्ज सब डिसबिलीव हो गलानी 449 दैट इज डिसबिलीव रॉबरी चार्ज डिसबिलीव एटा ही होची आपनकर मोटिव जे सी गोटे टंका पाइथिला ताकू रॉबरी करिया पाई ये घटना हला दैट चार्ज हैज बीन डिसबिलीव
And so far
And
the
you have not
election
filed appeal against that.
that is remained that confirmed.
and so
You
far
should have filed an appeal against that.
state has not filed.
Then
And so far the election dispute is concerned, Miller. That is not substantiated.
Election dispute आपण को पोस्ट पाई लड़ी होतला सेटार तो वीक अछि
whether ward member, sarpanch, nobody knows.
Only
And wife of Dilip contested.
Dilip has not stated it.
Dilip came into the witness box. You have not asked a single question to him.
So far the motive part is concerned, Miller. I think is and Miller cannot.
What have you collected so far as this reports you have state found? Any criminal antecedent against anyone? No. And
First time offenders.
Any adverse report against them in the jail after the post conviction?
No, Miller. It's conduct is.
With that affidavit you have filed.
That
report you have filed. Report you have filed. Yes.
And you must have also examined the witnesses in the surrounding probation officer जाइथिबो ना तांको घर को. What is their status?
जाइकिरे समाने जो सेटी statement collect कले.
Can you just
no
give
one
report?
says that they have any.
ते report टा देखे ना.
So
state जो report टा देखे. आंका affidavit जो बीट appellant जो affidavit देगी.
the only strength you had is that DNA test report. Mine is that DNA test report. You don't have anything.
You see, it's a case of triple murder. No doubt it is a heinous offense. And the entire family has been, because husband, wife, and that minor child. What is the age of that child?
8 years.
8 years.
8 years. But again, that you are to adduce the evidence regarding the involvement of otherwise merely because triple murder has been committed if the court doesn't find any clinching evidence, then yeah. ତିନି ଭାଇ ଅଛନ୍ତି ଗୋଟେ ଭଉଣୀ ସେମାନେ ସମସ୍ତେ ମ୍ୟାରେଜ living separately was leading a married life blessed with 2 sons and 1 daughter.
Only 2 persons, one Antarjami Sahoo and other persons, they stated something against this Prakash Behra.
Aja, this man is Prakash Behra is a married person. Taro Pita Puo gote jio. ତା ବଡ଼ ପୁଅଟା ଗ୍ରାଜୁଏସନ ପଢୁଛି, ସାନଟା ପଢୁଛି 8th standardରେ, ଝିଅ ହାୟର ସେକେଣ୍ଡାରୀ, BPL category family, wife ଦିନ ମଜୁରିଆ ବିଣାପାଣି ବେହେରା.
Nanda Kishore had a little bit problem. He was a jail conduct was, but he has reformed.
Nanda Kishore कौन भाषा against us किसी?
See, he was bit rude and all, but he reformed. So,
She be by Nanda Kishore.
Satisfactory.
Nanda Kishore, Ranja alias Nanda Kishore was leading a normal life. Two sisters, they got married. He belongs to poor family, BPL category, read up to Swanso. He was married, blessed with to the Chatardita Puo. His conduct towards the neighbors and others in the village was good and cordial. No past records of criminal activities were against him. Never his involvement in any disturbance in any antisocial authorities, activities. Okay. Elder son, Novamo class, son of was 6th standard.
On the other hand, let's see towards the bottom, page 3 towards the bottom. On the other hand, some people of the village, namely Basanta Naik, Dolapa Naik, and others, said that in addition to his normal livelihood, he was involved in village level politics. They said that although his behavior and conduct were appeared to be simple, in reality something else, and he's a cunning fellow, but he has no past criminal records.
Village level politics से तो आजकल
cunning fellow
प्राय बहुत ଆଉ ସେ ଯୋଉ ସେ ଗାଁରେ ଗୋଟେ ନଥାଏ ସେ ମଣ୍ଡପ ସେଠି ବସିକିନି ସେ ଆମେରିକା ଲଣ୍ଡନ ଠୁ ଆରମ୍ଭ କରି ସବୁ ପ୍ରକାର ଆଲୋଚନା ସେଠି ହୁଏ apart from
what is custody period, both of them? They were arrested. Total custody.
They were arrested on 12/10/2017.
12/10, 2017.
What is about their psychological condition?
Let's see page 5 of the report. As per kind orders of the Honorable High Court, both the convict Prakash Behra and Nanda Kishore Sethi were shifted to the district headquarters hospital Angul in order to ascertain the psychological condition. The reports of the associate and clinical psychologists received from the Department of Mental Health, DDS Angul, are enclosed here to cover kind perusal. Now the report is annexure 8 to the report. That is that.
किसी कौन गंडगोल अछि psychological report रे ना तो ठीक ठाक annexure केते कहले?
Annexure 8, Roman 8. Page 22. Page 22.
इनकी किसी नहीं तो ये
Last page
last page page
page 24 million.
24
towards the bottom. Current clinical interview and MAC suggestive of no cyclopath.
Psychopathology.
Normal speech, normal wants to thought disturbing found, perception no disturbance found. Post conviction period is okay. Not involved in any jail offense. and his conduct and behavior inside the jail premises has been very good and satisfactory since the date of admission. Same is also on the okay. What have you stated in your affidavit, Mr. Maurya? Upon affidavit ଦେଇଛନ୍ତି ନା?
Only ending member is family member. Having minor children.
ଏଟା ହଉଛି କାହାର ଆପଲା ନମ୍ବର 1 ର ପୁଅ ଆଚ୍ଛା ତ 20 ବର୍ଷ ହେଲାଣି ଠିକ ଅଛି 4/10/2017 and he was a daily wage earner Bappa Chila Moro. We have no cultivated land and my sister Nili Behra 16 ବର୍ଷ lost to second year. Younger brother 14 years 9 plus. Yeah. No conveyance. Mother of applicant number 2. So that's all. Any citation if you want to give on any point, including the death, you can give it on Friday. So we are just keeping it to Friday. We are not reserving the judgment today. We will reserve the judgment on Friday after you submit your written note of submission or any citations on that. Thank you. Prakash Behra. नंद किशोर सेठी आपणकर आज उभय वकिल बाबू सरकारी वकिल आपणकर आर्गुमेंट आज सरला आदि मैंने कहते से माने किसी लेखिकी देवे बा किसी डिसीजन जदि हुए मजीर दबा फेले देवे तेणु एथिपाई आपणकर केस का पुणी 4 तारीख दिन लिस्ट हम आउ 2टा बेले तार पुणी सेटा रहिबो सुनानी पाई तेणु 4 तारीख दिन एमजीएमती अपियर करचंती जेमती को जेल रु ये करिवे वकील बाबू भी अछंती से दिन भी रहिबे हला और 4 तारीख 2टा बेले हां से दिन सुनानी शेष हबो हला शेष होई कि आपनकर रिजर्व आपन मध्य आम पचारू जदि किसी कहवा कथा से दिन आपन भी कही पारंती ठीक तो हाँ आज तो किसी ओपन नहीं किसी फॉर्मल वर्क करी रखी 4 तारीख 2टा बेले
प्रेस अपील अच्छी की कन्वेंशन
प्रेस admission which is night only bail matters we'll take up on Friday